Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
Fireworks are not done.
We're doing commentary on the kid. I mean, he Anglican for his service. I didn't ask you to interrupt me.
Okay, I'm a little behind. Welcome back to the Court of Public Opinion. I'm the Recovery Addict. I told you I didn't have time to paint the bathroom, and then I just proved that I didn't have time to paint the bathroom, but I'm done. I'm done. I'm not sure what it looks like when it dries, but there we go. All right, we're going to back up just a second because they came back from lunch. They came back from lunch without us like 2 minutes ago. Hang on a second. Okay, there we go. All right, a big shout out to Reverend Beasy. Reverend Beasy, congratulations. First in chat today. Oops, it helps if I do this right here. Reverend Beasy, thank you. We're going to turn that down. We're going to get this ready. Ready, camera 2. Let's cut to that. Oh, lunch is just coming back as we speak. Excellent. All right. We're going to have a little break. We're going to catch up here in just a second, but we are like 2 minutes behind. So
have them send someone with more experience.
We knew you'd paint the wall, says Ann. Here's what happened. I was talking to my wife, and she's like, here's the deadline. The deadline is right here. It is what it is. And we've got people coming tomorrow in the Airbnb. Another lady's calling, wants to rent the Airbnb for the next 3 months after that. And so it is what it is. We're there. And we're going to have a bathroom tonight at some point, I think. Okay. Let's go. Let's go here. We need the counter back up. Looks like they haven't actually started. I'm gonna speed watch for just like the 2 minutes we're behind. Is that okay? I'm gonna go 1.25 speed, and then we'll kick back to normal speed as soon as we get caught up. Let's see. Let's say my name's up. Daybell's going. No news yet on the Alan Kelly trial. That's going to be this afternoon. Maybe the next 2 hours or so we might hear. Around 4:30. Yep. Okay. Why am I not hearing? Oh, they don't have audio yet. The judge has left the audio out. So, Mr. Mullet, our amazing gang specialist, this is funny because everything he talked about, everything he testified to about gang activity and the gang life and things, I literally took a class in high school called Gang Awareness, and they covered the same stuff. And they had people like him who like lived in Compton, for a while, and came and testified about gangs and taught us about all that stuff. It was fascinating. But yes, I can second everything he says. I guess I'm a gang expert as well. When's the next single coming out? Maybe in the next 2 days, I'm thinking. Kimbers, Ohio, welcome. You're on the KR with Brandy. That is awesome. I think his gang name is a Young Mullet. I had a gangster class. I did. We called it TAG, Teens Against Gangs and Graffiti. And we'd go around, and they had us go around and speak to like elementary schools. And we knew nothing about gangs at the time because it was like week 1 of class, and we're supposed to go stand up in an auditorium with a whole bunch of grade schoolers and explain why gangs are bad. We didn't even know what a gang was. None of us had ever seen one before. I can tell you that much. And it was fun. But we got like signs made up and posted in the city. This is a tag free or tag gang free zone or something. It was I don't know. I'm not even sure if it was even legal what we did, but we got a very loud buffer. I'm going to turn that down. Still waiting for the judge to come back. We're going to catch up before he even turns the volume up.
and Investigator Miller is back on the stand.
There we go.
Mr. Hiles, anything before we bring the jurors in? And they're all here. I don't know if you checked, but Ms. Niles checked also. We're going behind you on the numbers.
Nothing from the state, Your Honor.
All right, Ms. Miller, you ready for cross-examination?
Yes, Your Honor.
All right, Mr. Pritchett, anything we need to talk about before the jurors come in? Let's bring them in, please.
All right, jurors coming in. We're like a minute behind now, so we're going to be caught up in the next 4 minutes. DSN, thanks for the super sticker. I love it. Thank you very much for your support. It makes all this possible. You guys are amazing. Okay, put up a bunch of tags against tagging. That's basically what we did. And then we had our own T-shirts. It was like we made our own cool design that was like in gangster rap. Like it was like graffiti style. Honestly, our T-shirts against graffiti had graffiti style words on them. And then in class, all we'd do was sit there and listen to rap music. Kid you not. We'd listen to rap music, and then our assignment was to sort of break it down and translate it into the threats and the claims and the disrespect and the back and forth and the affiliations that were encoded in it. Crazy class. I got credit for that.
Thank you, sir. Everyone can be seated. Welcome back, ladies and gentlemen. Hope you had a good lunch. Thank you for being on time. We're on time. It's about 1:30. When we stopped, Investigator Williams and Miller had finished his direct examination, and it is now time for Ms. Mignot, if she has any cross-examination for Investigator Miller.
Thank you.
You're welcome.
Good afternoon, Investigator Miller.
Good afternoon.
All right, I'm going to be following up to some of your testimony this morning, and I wanted to start with your experience as an expert in gangs. Is in terms of the slideshow that we saw this morning that you presented, the information you got was you pulled it from Wikipedia, correct?
No.
You did not pull the slide, the information that you placed in the slide from Wikipedia?
No, I did not.
Okay. As it pertains to
your Wikipedia expert. That was
the information that spoke about 1.5 million active street, prison, and OMG gangs. The first slide that you had up that had 2011 on it, you got that information from Wikipedia?
No, I did not. So that last study is from 2015. The picture depicts 2011, but the actual last study from the FBI was done in 2015 that actually demonstrated 1.4 million active gang members throughout the nation, and the over 30,000 gangs operating across the nation as well. That came from the FBI.
Okay, so you got it from the FBI's webpage and their information that they publish?
No, I actually got that specific information and that specific threat assessment directly from the FBI.
Okay. If it's on Wikipedia exactly in the same format, would that just be a coincidence?
It would, because that's how it is in their actual security threat assessment.
All right. Now, in the National Gang, are you familiar with the National Gang Intelligence Center?
I am.
Do they have a website?
They do.
All right. And isn't it true that on their website, they have depicted that the four main gangs are National Street Gang, the Prison Gang, Motorcycle Gang, and Local Street Gang?
So those are different categories of criminal street gangs. National. So national would be your large traditional gangs such as Bloods, Crips, Gangster Disciples, Vice Lords, and so forth. Prison gangs are gangs that are operating primarily in the prison. Outlaw Motorcycle Gang, OMGs, those are 1% criminal street gangs. And sorry, what was the last one that you said?
Local street gang.
Local street gangs, and that would be that hybridization that I categorized.
All right, so let's talk about your expertise. I believe you stated that you've had, is it 20 years of experience?
No, I started my law enforcement career in 2016.
Okay.
So how many of you guys are on Wikipedia like me?
In 2016, did you play any roles in investigating YSL gang membership?
In 2016, I did actually interact with several YSL members. I also investigated or assisted in an investigation involving, obviously I wasn't the lead investigator because I was still fairly new to law enforcement, but I was documenting an individual who was associated with YSL and involved in a homicide investigation in Douglas County.
Okay. And as it pertains to your years of experience, how many would you say that you've been lead investigator or lead involved in an issue associated with the YSL gang?
Several times, over 10 for sure.
Okay. And was any of those 10 times or a little over 10 times associated with the Fulton County District Attorney's Office?
Yes, some of them have been, yes.
Okay. So it's a fair statement to say that the majority of your knowledge and expertise regarding YSL came from your employment with the Fulton County DA's office?
No, I investigated YSL when I worked for the DeKalb County Police Department, Douglas County, and Cherokee County District Attorney's Office. I actually worked several YSL cases in all of the jurisdictions, mainly because YSL members don't necessarily just operate and commit crimes in Fulton County. However, they do have territory in Fulton County. They do commit crimes throughout the state.
Now, as it pertains to the information you provided today, you testified that you can either be jumped in to YSL.
Yes.
All right. You don't have any information that Mr. Robinson was jumped into YSL, correct?
No, ma'am, I do not.
You also testified that you could be blessed into YSL.
Yes, I did testify to that.
And you don't have any evidence for this jury that Mr. Robinson, my client, was blessed into YSL.
That is correct.
And you also testified that one of the other ways that you can enter is to be sexed into YSL.
Yes, that was my testimony.
And you don't have any evidence that
She
Mr.
went
Tyrone
there.
Robinson was sexed into YSL, correct?
She went there. I'm sorry. I'm like, don't do it. Don't do it.
Now let's talk about the testimony
By the way, Reverend Beasy, thank you
as
very
it
much.
pertains
First
to
in chat. The
your
internet is
role
all yours, my
in
friend.
this case that we're here for regarding Wiley Street.
Okay.
You don't have any information that would support that the Wiley Street incident was orchestrated by YSL, correct?
I do. There's orchestrated.
Yes, this robbery was planned by YSL. It was YSL's idea.
No, that it was orchestrated by it, yes. So from the case summaries that I have received, it was planned with the individuals involved who were arrested, and they committed the crimes. Can you be more specific?
Okay.
I'm not really.
So let me rephrase my question. The plan, the idea to commit a robbery at the Wiley Street location in this case, you don't have any evidence that that plan was initiated by YSL, correct?
I would consider the other defendants in the case that are not YSL members, I would consider them actually associated with YSL. So in a degree, yes, it was orchestrated and planned with YSL.
Okay, so let's get specific since you said that.
Okay.
According to the evidence in this case, the idea to commit the Wiley Street robbery came from Lauren Riley. Are you familiar with Lauren Riley in this case?
I am familiar.
Okay, Lauren Riley, you don't have any evidence, is a member of YSL, correct?
She is associated with Young Slime Life, yes.
Okay, my question is Riley a member of YSL?
Not to my knowledge.
Okay. And you are making the connection to YSL based on the fact that she may have gone to parties with somebody involved with YSL, right?
No, commit crimes with YSL, that would be the association aspect.
Okay.
And hanging out with them, that would be the association aspect.
Okay, so let's be clear. You testified this morning that you can be a member of YSL, not commit any crimes, and it not be an issue, correct?
That is true.
And if I'm a member of YSL and I'm not committing any crimes, right?
Yes.
Are you testifying to this jury that you would still connect it to YSL just because Miss Lauren Riley was part of the initiation of it?
Connect what?
Connect the crime.
The crime, yes. YSL as a whole can benefit from a crime committed by members of YSL. May not be enough to charge that individual itself, but would the gang benefit? Absolutely.
Okay, what would be the gang benefit if Riley is the person initiating the robbery in this case?
So if we're just talking about Riley and she didn't have the hypothetical of being associated or committing this crime with other individuals?
We're talking about this case, Wiley Street robbery,
yes,
which is Lauren Riley's idea.
Okay.
What is the benefit to YSL that Lauren wants to rob someone?
That's not their benefit. Their benefit is YSL members committing the crime and then collecting proceeds from the crime. That would be the benefit.
Okay. So if Miss Riley and her friend Lauren Kalish are the two individuals that committed the crime, that would have nothing to do with YSL, correct?
If they were the only two that committed the crime?
Yes, sir.
And they just acted it out completely by themselves?
That's correct.
And they took proceeds and gave it to YSL members?
No, they took proceeds and gave it to themselves.
If they just committed crimes by themselves, I don't see how that would be. I'm sorry, I don't see how that would benefit the gang, no. If it was just them two and it was just them two alone, no.
Okay. And as it pertains to the Wiley Street robbery, you don't have any evidence whatsoever, based on your involvement in this case, that Mr. Robinson was present at Wiley Street when Lauren and Lindsay robbed the Wiley Street location, correct?
No, just the communications that I've reviewed in the case summaries.
Okay. As it pertains to what you've reviewed phone records, right?
I have reviewed some of the phone records.
And isn't it true that the phone records you reviewed does not show Mr. Robinson as the subscriber of that phone?
I would have to reflect my memory, but if you say so, that's probably true.
Okay. And in fact, the documents you testified from earlier today, which showed an email address for Robinson, Tyrone Robinson 999 at Gmail. Do you remember testifying to that?
I do.
If there are two Tyrone Robinsons that have come up in this case, you don't know which one of them it belongs to, correct?
No, I do not have independent knowledge.
Now, let's talk about how you determine whether somebody's a member of a gang.
So I'm looking at...
No, she has to ask a question. It's not like on direct where Mr. Heil said, hey, what else do you think?
That was the question. I apologize.
That's okay. It's all right. It's a different mode. She's going to zero you in.
Sounds good.
Thank you, Your Honor. Okay, so let's talk about your testimony this morning, that this case you investigated only as it pertains to the gang aspect. Is that accurate?
I was just looking at the gang evidence. That's
okay.
Correct.
And you're looking for gang evidence to say, hey, one, is this coming from a YSL gang member, right?
Yes.
Okay. And you're looking for, was a YSL gang member present at the scene of the crime?
Yes.
You're looking for, did a YSL member benefit from the proceeds of the crime?
Yes, that would be an indicator, yes.
And those things you are able to corroborate based on cell phone tower evidence, right?
I did not go through the cell phone tower evidence. I specifically just was reviewing identifiers as far as images, terminology used, just the actual aspect of gang identifiers in this case.
Okay. Isn't it true that there are people, especially young people, we're talking about 19-year-olds and 20-year-olds, that will change their vanity or their handle or their social media name to use what they've seen, either an artist or a gang member or somebody they idolize on their social media platform?
She's talking about you.
And using it does not mean you are part of it, correct?
No, not necessarily. Context matters, totality matters.
Okay. And based on what we looked at this morning, you showed several slides of someone else's social media account, right?
Yes, in the first half of my PowerPoint presentation, most of that is just showing generalization. These are some of the identifying signs that they utilize. And then the other portion of my social media was specifically the accused in this case is of them and their identifying signs with the criminal street gang.
So the picture that we looked at where you alleged Mr. Robinson was in that photograph. We're going to see if we can help you out.
Yes, please.
Mr. Robinson is in the photograph. You are determining that Mr. Robinson is part of a gang based on him being in a photo, correct?
Not just one photo. I look at the totality. So if I see several photos of an individual throwing up YSL with a green bandana in their territory and with other known documented YSL members, I'm looking at a totality of all of that. If I just had one photo of an individual doing like this, depending on the context, it could be, yes, they're a YSL member, or it could just be they're a kid imitating something they saw on YouTube. So totality matters, context matters.
Permission to publish, John?
Yes, ma'am. This is, I'm assuming you're using pages from States 38.
That is correct.
Published whenever.
That's correct. Okay. So you just testified that context matters and totality matters, correct?
That is true.
So using this photograph that you testified from this morning, do you see my client in that photograph?
I do.
All right. And he's wearing the exact same shirt in all three shots, right?
Yes.
Isn't it true that that is the exact same photo cropped by you in three different ways?
Yeah, yes, ma'am. I pulled them from the records and I put them onto one slide.
Wait, how is that the exact same? I'm sorry. He's standing next to different people in two of the pictures and he's seated in a truck in the third. How is that all one photo?
So it's not one photo. These are three individual photos that I put on one PowerPoint slide presentation.
Okay, because your answer was yes, it's all the same photo. I cropped them differently.
I apologize. I thought she was asking if he was wearing the same outfit in all photos.
Okay.
He was wearing the same outfit. These are three individual photos placed onto one PowerPoint slide.
Okay. And isn't it true, sir? You got all three of these photos from the video that was played this morning.
I did not crop these individual photos from the YouTube video. These are individual pictures that were completely, no, I did not collect them from the YouTube channel.
Okay, not the YouTube channel. We played a rap video this morning.
That's true.
You recall seeing it?
Yes.
And it was the first one we played.
It was banging.
And it was called Guns Up. Remember that being played?
Yes, I do.
Isn't it true, sir, that what you did is took one day of a photograph of a video and placed it in 3 different places because there are 3 different angles from the video that created these 3 photos that made one slide?
So I didn't personally crop the photos. I just collected these photos and then pasted them onto this PowerPoint.
Collected them from where? Where did you find these 3 photos?
These were collected in Robinson's phone and his Instagram records. The actual video itself is a completely separate file that I publicly viewed on YouTube. I didn't take any individual crops of that YouTube besides the recording of the video.
Okay, so it's your testimony that it's a coincidence that he's wearing the exact same shirt in the video?
No, I'm saying that this likely occurred from the same time they recorded it, but I didn't obtain these photos from the video. You said I cropped.
Okay.
So, I personally did not crop photos from a YouTube video.
Okay. So let me ask a different question. If this is the exact same day, but 3 different shots of him on the exact same day, it would be fair to say, if context matters, it's one incident, correct?
That is accurate. This is, I would assume, the same day because he's wearing the same outfit. The other individuals depicted in the YouTube video are wearing the same outfit as in the music video. Yes, I would assume that it would be from the same day.
Okay, and it would be unfair to take one music video that he's in and say, gang member, YSL, right?
Not necessarily, because I'm looking at the context of the individuals involved, specifically what is being shown to me. So I'm seeing several different identifiers on this day, as well as I have seen and observed on other days the same terminology, same identifying signs.
Okay, and you've seen them from actual members, right?
Sorry, say again?
You've seen those same identifiers from actual members of YSL, correct?
Yes, multiple members of YSL.
Okay, and if I am not a member of YSL, and I'm just a young, impressionable teenager that showed up for a video shoot, you would have me in that video, correct?
If you were depicted and captured on that video. I mean, there were several people there at that event that I have other pictures from that weren't necessarily in the music video. But yes, you could be depicted in the music video if you were there.
And based on your standards, you would say I'm a member of YSL gang, right?
If you were just present?
Correct.
That's not really enough identifying signs for me to say someone is associated or a member if they were just seen there. I'm looking for the totality. So hand signs, what are you wearing? What are you saying? What are your actions? What are you doing? The context and totality matter.
Looking at the 3 different shots with him wearing the exact same clothing, there's nothing unlawful about this shot that we're looking at, correct?
No, ma'am.
Okay.
The AK down the pants might be pushing it, though. Just saying.
All right, so I'm showing you what you had identified this morning as your triangle to show or depict the connection as to how you determine whether a group is a gang or not, right?
That's true.
All right, and what you have here is the word gang, and you used a green, what I thought was a magic carpet, but it's supposed to be a bandana, right?
That is correct.
All right, so you used a green
Could be a magic bandana.
Judge beat me to it.
and the word crime and person, right?
That's true.
So this person you're saying is a member if they're using a green color, right?
No. So I'm not ever looking for one identifying sign. I'm looking for a totality. So hand signs, colors, clothing, terminology, several things. If one person has a tattoo that is an identifying sign of a criminal street gang, that doesn't necessarily mean that they are a member or associated of a criminal street gang. I'm always looking at the totality. There isn't an exact number, but I'm looking at multiple things. So if someone's just wearing green, that doesn't necessarily mean that they're a member of YSL. That's not enough for me to say and comfortably say. Individuals can be mislabeled. So I'm looking at several identifiers.
Okay, so let's use this slide. Okay. You took a picture of my client and you threw it up on your Slack, right? You created this. Is this your PowerPoint?
I did create this PowerPoint.
Okay. And you took a picture of my client and you put it in your triangle as a person, correct?
I have.
And it has to be 3 or more persons in that area, correct?
In that era?
In order to determine a gang, your definition this morning, you needed 3 or more persons. Am I accurate?
Yeah, that is accurate.
We're caught up for life now.
And you have in this depiction only 1 person, right?
That is correct.
So this is not truly an accurate definition of what is required for us to close this triangle as it pertains to definitions of a gang, right?
So it is. So the 3 aspect is 3 or more members, whether formal or informal. That's the top part of my triangle. So the gang aspect. So I have to establish that the gang exists. So 3 or more individuals, whether formal or informal, are engaged in criminal street gang activity.
Don't talk too fast.
Yes, Your Honor.
Please.
They have to have an identifying sign, symbol, or some type of characterization that they go by. So Young Slime Life, YSL, they use the color green. They have more than 3 members. They do commit crimes such as murder, armed robberies, aggravated assaults, home invasions, burglaries, drug offenses, a slew of offenses over the years. And then I'm showing the person, so the person who is charged with the crime, how he is connected to the criminal street gang.
Okay, so let's talk about the definition. What you were just testifying to this jury is this definition you showed this morning, 3 or more persons associated in fact, right?
That is correct.
And then it's formal or informal, and then they engage in a criminal gang activity.
That's correct.
Is selling drugs a criminal gang activity?
It is.
Does it matter if it's marijuana gummies or marijuana wax or ketamine?
No, all drug offenses, including misdemeanor marijuana.
All right. So if I have a party and there's 3 or more of us at that party, and say, for example, my gang is the Models gang, right?
Okay.
And we put on an informal event because we don't have bylaws or anything like that. We're just informally meeting. And this is what we do. We just keep meeting. And what we do is we sell drugs. That would be engaging in criminal gang activity, correct?
If the model gang has 3 or more members, they have a identifying name, such as the model gang as described, and they sell drugs, that would be considered under the definition of the Gang Act would be a criminal street gang.
Okay. Now let's talk about this case.
Okay.
You don't have any evidence that places my client, Mr. Robinson, at the Wiley Street robbery that was constructed by Ms. Lauren Riley, correct?
Not outside of tests or statements.
Okay. Let's talk about electronics then.
Okay.
Do you have any cell phone that puts my client at the Wiley Street robbery?
Not that I have reviewed.
Okay. Do you have any cell phone tower that puts my client at Young Band's house?
I didn't review any of that.
Okay. And it would be important to review it because you're trying to connect this to a gang, right?
No. So that would be connecting the crime and proving the predicate offenses. The lead investigator, whoever did that, handled that aspect. I reviewed case summaries, and I'm looking for the gang evidence, not the actual investigation, the literal predicate crime.
But the predicate crime cannot be bifurcated from the gang if you're saying that this is gang related, right?
That is correct. That's why I'm reviewing case summaries like that. If I was the lead investigator handling the case, sometimes I would do it all. But in this specific case, I didn't do the entire investigation by myself. All I did was review the gang evidence and case summaries.
Okay. But you are required to corroborate or work with or cooperate with the lead investigator on this case, right?
I don't know if I'm required by law. No, I'm not.
Well, it makes sense if you all are working together on the same case, right?
Yes. Some investigators have retired and moved to other units and so forth. So typically, if a published final case report is established, then sometimes I will do my work on the back end. Best practices is typically working on the front end, but the evidence is the evidence. So I just reviewed what the investigators that conducted the investigation had done.
Okay, and did you review that in this case?
Yes, I reviewed case summary and the gang evidence and some cell phone records.
So you are aware that there's no evidence that places my client at Wiley Street, right?
So you've asked him maybe 5 times now about evidence at Wiley Street.
I'll move on from Wiley.
Okay.
Although that's the reason why we're here.
Okay, and he's answered every time, nope, I don't have that evidence.
Got it. As it pertains to Young Bands, the 14th Street location condo, you don't have any evidence that my client was at that condo on November the 8th of 2019, correct?
No, I do not.
You stated that the gangs are comprised of smaller hybrid gangs from Cleveland Avenue, right?
Yes, originally, yes.
You don't have any evidence that my client is from Cleveland Avenue, correct?
No, I do not.
You don't have any evidence that our client is from Creek City, correct?
I do not.
Don't have any evidence that our client is from or affiliated with Young Loyalty, correct?
No, I do not.
You don't have any evidence that our client is from the Browns Mill Road or Jonesboro Road area, correct?
I do not.
These questions go for a while, I guess.
Now, you have to interpret a lot of what you would call terms used by groups that you refer to as gangs, correct?
Yes. Yes, I interpret a lot of things that different criminal street gangs identify themselves with. I get a lot of this information from the gang members telling me, whether it be interviews, whether formal or informally interviews, such as custodial interviews or non-custodial interviews. But yes, I collaborate with several different reasons to base my opinion on how I interpret these identifying signs.
Are you aware that the term YSL stands for more than just a gang?
Yes. So the terminology it's commonly known as young slime life. However, there's also other terms such as young stoner life, or there's different creative measures of why they would change their name of YSL. But it is commonly known on the street, within the gang, and within rival gangs as young slime life.
Are you aware that Young Stoner Life is a record label company?
Yes, I am familiar that Young Stoner Life is a record label that also goes by YSL.
Okay. And if I am a rap artist that is signed with Young Stoner Life record label, it's not uncommon for me to use YSL to represent them, correct?
Yes. If the individuals who are actually signed to Young Stoner Life, they're signed by Young Stoner Life and they're on their website and get paid to rap and record, and they're legitimate artists signed by that record label, which is a legitimate business.
Now, as it pertains to the social media played a large role in this case and in your decision to say for certain from that stand that you believe Mr. Robinson is involved in a gang that goes by the name YSL, right?
That is correct.
And isn't it true that all the social media, whether Instagram account, as you testified this morning, is controlled from that device that you saw depicted in the exhibit the state showed you by the subscriber, as you testified this morning?
Yes.
Okay. And if Mr. Robinson is not the subscriber, it's controlled by someone else other than Mr. Robinson, correct?
Yes, it could be.
And if I post on my social media and you comment on it, I cannot control your commenting, correct?
I mean, you can block someone, you can delete someone's comment if you wanted to, but it also depends if your account's public or private. So you can kind of control who comments on your stuff that way, in a way. So depending on how you're asking.
So let me clear it up. If the subscriber, which you know not to be Mr. Robinson, didn't block anyone from commenting on their post, Mr. Robinson doesn't have any control of that, correct?
If it's public, then it's public. So anyone can just comment whatever they want. If it's private, you can control that aspect as an account holder.
Okay. And if he's not the account number holder, he's not the person that can control it.
No, it would have to be whoever's in possession of that account.
Okay.
Do you have to be the account holder, or do you have to be someone who has the ability to manage the account? You've got let's pretend, an Instagram account you unwisely share with me. Hey, here's my login information. I could get in there and make things private, block people, moderate, as long as I don't have to be Investigator Miller. It's not a thumbprint kind of thing.
That is correct.
Okay.
And based on the court's question, you don't have any evidence that Mr. Robinson accessed a third party or the subscriber's account that we're talking about here?
Not to my knowledge.
Okay. Now, jumped in, blessed in, and sexed in. Isn't that also sometimes the way you get into a fraternity when you're in college?
I mean, that would be some extreme hazing, but you could consider it, I guess.
So are fraternities considered gangs?
No, so there's a huge different aspect of what a fraternity versus a criminal street gang. So fraternities do great things for the communities. They do community events. They're, it's a networking stuff. If they're committing crimes, that fraternity would look bad. Whereas criminal street gangs, their entire aspect of how they operate is through criminal street gang activity.
Isn't it true that if I'm a member of a fraternity and I go out and I rob the Burger King 12 burgers and bring them back and share them with the other people in my frat house, that's benefiting, correct?
But
is that a yes or a no first?
He can give his whole answer. The yes or no can be anywhere in there. So let him answer. If he doesn't answer, let's ask it again.
I would say no, because I don't personally think that crime would benefit your fraternity. I think your fraternity would look bad that you stole. I think that you'd probably be disciplined, probably kicked out of your fraternity for that, maybe even disciplinary arrested. The status of what type of fraternity matters as well. Like, are you a college student? Are you a philanthropist? I'm not really sure, but whatever type of fraternity you're committing crimes for, that would be a bad look. And most members of the community aren't members of a criminal street gang. If they are a member of a fraternity, they're a member of something positive for the community.
Oh, so could that be your position because of race?
Absolutely not.
Okay. Now, you testified this morning that there is racial components associated with the gangs. You remember that?
Depending on what gang, there are some that are strictly hate and racist, or race motivated. Some aren't. Some are just because of how they set up. It really depends on what gang specific. There are several white gangs, there are several Hispanic gangs, there are several African American gangs. There are some that don't have a rule or any preference to what race matters, or some that's their entire focus is you can't intertwine races and like supremacies.
Now, the majority of the street gangs that you have been involved in are associated with rap music, correct?
Not necessarily. I mean, I've investigated hundreds of criminal street gangs. Some have rap music, some don't.
And rap music in and of itself doesn't make you a member of a gang, right?
No.
And that's even if I do a video with somebody you believe is part of a gang and ask them to be in my video, correct?
I mean, if I've identified someone as a member of a gang and they're making a music video and then they invite other people to their music video and I'm seeing identifying signs of their gang, then yes, I would say that would be associated aspects of the gang. I mean, it really just depends on the specifics and the totality of that.
What if I only showed up because they were going to pay me $100 to come dance in the video and to hold weapons and act like I'm part of the group and wear certain colors? That wouldn't make them members of the gang, right?
Not necessarily, no.
Okay. And as it pertains to, I believe you talked about white supremacy gangs?
There are white supremacy gangs throughout Georgia and throughout the nation, and they're international as well.
How many have you connected to a genre of music?
So Ghostface Gangsters is a primarily white criminal street gang. It originated in Cobb County. They have common identifying signs such as 767 for GFG, Ghostface Gangster. There is a rapper who goes by the nickname Bam Bam. I cannot remember his government name off the top of my head because it's been a long time since I've investigated him. He was involved in a homicide with a hatchet. He's currently in Department of Corrections, but he frequently releases rap videos on Spotify and YouTube.
Have you ever had any gangs that you've investigated that you connected country music to?
gangs I've committed country music to. I can't honestly say that I have. No.
What about R&B music?
R&B, yes. So there is a R&B artist that goes by the name Jaquez. He's actually a member of YSL.
Okay. So as it pertains to any type of genre of music, the ones that you're familiar with prosecuting is either rap or R&B?
When you say no one's prosecuting music, I guess I don't understand.
Let me rephrase the question. The ones that you've been involved in investigating or testifying regarding making the connection to the gang using music as a form of part of the role that you would play in the gang have to do with rap music, correct?
When I have investigated a crime,
that would be.
Your question is very broad spectrum. So I'm trying to answer it properly.
Well, I just want to be careful if I'm not asking my question properly, because what I'm asking about is the genre of the music, not necessarily the broadness or the nationwide.
I don't investigate music genres. I investigate criminal street gangs and criminal street gang activity.
Okay. And based on your investigation of criminal street gang and criminal street gang activity, you've never had a case where country music was playing a role, right?
I don't believe so.
Okay.
Ma'am, that would be for divorce lawyers.
Now, there was a picture that was depicted this morning that you testified from where you stated that the sign that we saw where two fingers were being used in that picture is part of the identifiers that you use to determine that my client is involved in the YSL gang. You remember that testimony?
Before I answer this question, I just remembered I actually have investigated or been an assistant on an active investigation that involves a country artist, but not his music. So I don't know if that differs from the country genre, but the genre itself, since he does sing country, if that answers that. But it was a one time.
Okay, I moved on to another question.
I know. I apologize. I just recalled, and I just wanted to set the record straight on that.
Or twist it. No, I'm just kidding.
No, I did not want to twist it. I just wanted to clarify because, I mean, it's been a long time since I investigated that case.
Okay.
But could you ask your?
So my question is about the signs that you said that are identifiers that you use, such as fingers and hand gestures, correct?
Okay.
And you testified this morning when you saw, it was shown to you by the state, a picture where there were hand signs in those photographs. You remember that?
Could you show me the picture?
Show me the pictures. I don't know what she's trying to
We're having
accomplish.
to be careful here because
You don't need to narrate. Just pull up whatever slide you want to pull up.
Okay, so can you see this slide, sir?
I can't.
Okay. Now, can you see where the finger of the person you circled this morning as my client at the gas station in the center photo, the center one?
I can't.
First of all, that post is not from my client, correct?
No, this is posted from another individual that goes by the vanity names Slim Santana.
Okay. And this post, first of all, my client could not control unless he has Slim Santana's account and he goes in, logs in with his password and posts this picture, correct?
That's correct.
All right. And now looking at his pose in the picture, do you see where he has two fingers pointing at the camera?
So I see him holding up this identifying hand sign.
Okay. Now, have you ever seen individuals? You remember when, I guess I'm going to be aging myself, when you were younger, if you wanted to bomb somebody's photo, you would do like this behind their head in the photo. Do you remember that?
Like the bunny ears?
Like the bunny ears?
I have seen bunny ear photos.
Right. If I were, have you ever seen now recently too, where some people, in order to look fresh or to look young, when they're taking a picture, they might do both hands like this in the pose?
Yes.
All right. If I do this in my picture at a birthday party or something, it doesn't make me a member of YSL, right?
That is true. I'm looking at the totality. So This is not a YSL hand sign. I'm looking at this specific hand sign.
Okay. And if I did that specific hand sign, it still doesn't make me a member, right?
So that is actually, is this what you just did?
Whatever he's doing in that picture.
Pretend she's doing that. She didn't, but that's okay. Pretend she did that.
So if you were pretending to throw a YSL hand sign,
yes,
and that is the only picture I've ever seen of you, and that's it.
Okay. What if you saw it and I was wearing a green bandana? Now I'm a member?
If I just see one picture of someone wearing a green bandana and just this, I would say those are strong identifiers, but I do not personally feel comfortable saying that individual is associated or a member of a criminal street gang.
Okay.
I like to look at it a little bit more than just one thing.
What if I did the finger, have on green, and I'm in the video? Does that make me a gang member?
No, it could, but once again, totality matters. There's a lot of different aspects that matters.
Okay.
But if it's just a one thing, the only thing that I've ever seen, I personally do not feel comfortable saying, just on this one day and at one time, this individual wore a green bandana and threw up a gang hand sign, because I don't know the context in this hypothetical. It could be you are a paid actor or shooting a movie in this music video. I truly don't know. So I'm looking at the totality of the aspect.
Now, as it pertains to what we're looking at depicted here that the state asked you about this morning, my client is wearing the same outfit in the slide in the center and the slide to the right, correct?
That appears to be so.
Okay. And it looks like it's the inside and outside of the same gas station, right?
It very well could be, but I do not know.
Okay. Did you investigate if it was the same day, a different day?
I don't even know what gas station it is. Okay. So no, I have no idea.
And context matters, right? Because if that's the same day, you wouldn't say, oh, there's two different occasions that I saw your client putting up signs, and because he's at more than one location, now he's a member of the gang.
No, I mean, I'm looking at the totality of aspects. So if I see several photos of the same individual wearing the same thing, throwing the same thing, even on different days, and with music videos, rapping about the same thing, I'm looking at the totality, not just one picture.
Okay. And the farthest one to the left is he's wearing the same outfit that you showed us in the other slide that we looked at earlier, correct?
That is correct.
Okay. Isn't it true that there are young people across Atlanta that are claiming to be members of gangs that they're not?
I'm sure it possibly exists. The reality is, though, when I have investigated crimes that involved individuals who are false claiming, it doesn't end well. Whether it's some type of extreme violence of a shooting or an assault of some sort, when it does happen. But does it happen? It does, and it can happen.
But it doesn't always happen, right?
I don't know.
Isn't it like trying to find out who's using your music? You literally almost have to hire somebody to make sure they're watching the internet to see if somebody's publishing it. Isn't it the same way as it pertains to if somebody is in high school and they're taking pictures or they're using our signs or they're wearing our colors? YSL is not going to high schools to look around to see, hey, is this kid pretending to be one of us?
So there's several YSL members who are juveniles and actually go to high school, and they're real members and commit real crimes. So if they encountered an individual who was falsely claiming to be YSL, yes, they would absolutely commit some type of violent act against them.
Okay, so let me ask my question again, because I must have confused you. Isn't it true, sir, that YSL is not going around to high schools throughout Atlanta, based on your knowledge of gangs and your expertise, looking for high school students that are falsely pretending to be members?
I must still be confused because there are YSL members who are in high school and who are actively seeing if someone is false claiming, and they will commit violence, and they have committed violence.
So you've answered her question. Next question.
All right. So as it pertains to music, music is an art, correct?
Yes.
And it's an art that I can use to express myself, correct?
That is true.
All right. And you testified this morning that some of the lyrics that we heard in the two videos that were played is an expression of, I will commit crimes as a gang member. You remember that?
Yes. Some of the lyrics specifically were talking about pistol whipping and robbing and selling of narcotics.
Okay. Isn't it true that the majority of the theme, if you understood some of what they were saying, because some of it I did not understand, was talking about if you come for us, we'll come for you?
Yes, that's one of the aspects of in gang culture. If one gang has a rivalry with another criminal street gang, if one member is killed, there's a retaliation that occurs with that, and vice versa.
Okay. Isn't it true that that is a sentiment even of families?
That is true. In domestic violence, that could happen as well.
And if I'm a mother and I say, if you come for my kid, I'm going to hurt you, that's a normal saying, isn't it?
If that's what you're saying, that is what you're saying.
That wouldn't make me a member of a gang, right?
No. Being a mom does not make you a member of a criminal street gang.
All right. So are you familiar with the artist Bob Marley?
Who? I am familiar with
Bob Marley. You familiar with Bob Marley?
I am familiar with Bob Marley.
One of his famous songs were, I shot the sheriff, but I didn't shoot the deputy. Based on the standards that we're using now to determine who's a member of a gang or not, he would be arrested for that?
I don't believe Bob Marley is a member of a criminal street gang.
Okay, and that's based on what?
I don't have any evidence that Bob Marley is a member of a criminal street gang.
Okay, so you don't know that?
I have no evidence that Bob Marley is a member of a criminal street gang or ever formerly was.
Is she pouting right now? What's going on?
Gentlemen, I just have 1 second.
Yes, ma'am.
No woman, no cry. Gordon. Good song.
No further questions, Your Honor.
Turning to the accused, sir, do you have any questions for Investigator Miller?
Yes, sir. How you doing today, Mr. Miller, correct?
Good afternoon. How are you doing?
I'm good.
It'd be funny if you responded.
Can you just refresh my memory on how long you've been a gang expert?
As soon as the Honorable Judge McBurney qualified me as
Okay.
I love that.
Have you ever been in the gang?
I have never been a member of a criminal street gang.
Have you ever been harmed directly or indirectly by or threatened by any street gang?
Yes, so I have been shot and stabbed twice by a white criminal street gang member, a member of the Ghostface Gangsters. I have also been in physical altercations with several different criminal street gangs, such as Sex, Money, Murder, Neighborhood Rolling 60 Crips, Gangster Disciples, and several other criminal street gangs that while working in my law enforcement career.
So he's got cred.
So could these harmful interactions with these individuals, could that have caused a bias on your opinion towards people you consider to be in gangs?
I don't believe so. I'm looking at the totality of everything. that's just kind of part of the job. What happens at me as far as injury, I didn't take it personal. It happened. I have moved on. It's not my first time being shot or stabbed. So no, I don't have any bias opinion. And each and every single one was different gangs, different people, different races, different circumstances. So no.
The answer is no.
Now, according to your ways to join a gang, do you have any evidence that I was ever jumped in YSL?
I do not.
Do you have any evidence that I was ever blessed in YSL?
I do not.
Do you have any evidence that I was ever sexed in YSL?
I do not.
Just copying their questions.
So you know that I've joined YSL off of your assessment of the totality of what you have seen?
That is correct.
If LeBron James had a picture of him throwing up a YSL hand sign in one picture, another picture with him wearing the color lime green, and another picture supporting a friendly artist, let's say for this instance, Gunna, would he be a YSL member?
I would be looking at the totality, but I would not say LeBron James is a member of YSL based off any evidence that I have personally seen. But if he was supporting Sergio Kitchens, aka Gunna, who is a known individual of YSL, while also throwing the hand sign and wearing the same colors and was pictured with Sergio Kitchens, then yes, he could be associated with YSL based off of that information.
So that would definitely make him a member.
No, he could be associated if he was seen with Sergio Kitchens, Gunna, or someone else in doing those things. But I look at the totality aspect, not just one thing.
Okay.
We have to wait till the hearing before we hear what happens, Casey. It's going to be in maybe 2 hours.
Now, you said that you are aware that there are individuals signed to YSL as artists and rappers and creatives?
That is true.
Can they be incorrectly identified as gang members?
Most of the rappers that are signed to Young Stoner Life are active members of Young Slime Life. They're commonly displayed in their social media and music videos. Some of them have been arrested for violent crimes or have been associated with violent crimes. But could they? Yes, there could be someone on there that I'm not familiar with that is not involved in criminal activity.
So it's possible that an artist signed to YSL can be mistakenly taken as a gang member of YSL. The possibility exists. It's
a possibility, but I would have to see that individual myself without, to actually say yes. It's just it's just a hypothetical that I'm not familiar with, as far as I haven't looked at that specific individual of a possible. I just don't know.
So you can be an associate of a gang and not a member, correct?
That's correct. So under the Gang Act 1615-4, you can be charged under the criminal street gang activity for being associated and not a member.
Okay. And what differentiates the two? Like, what's your main basis of what differentiates the two from an associate and a member?
So associate could be someone that may be employed or is connected to the crime somehow, some way, with another individual involved who is a member or also an associate of the gang. So, as an example, if I have a defendant who I have no identifying signs that they're or any type of evidence that they are a member of a criminal street gang, but I have evidence that they committed a crime that directly, or if they were even employed to commit a crime by the gang or a gang member who I do have identifying signs and evidence on, that could be an association of a criminal street gang that benefits the criminal street gang itself by not being a member.
Okay. And according to your assessment, have you ever seen me throw up the YSL sign?
No, I have not.
According to your assessment, have you ever seen me use any of the YSL verbiage?
I can't recall at this time, no.
Okay.
Is he saying he's not a member?
Okay. So your totality of your assessment of me being a gang member was based off 3 photos.
So I'm looking at the photos, specifically green bandanas, posing in photos with other individuals who are claiming to be YSL with hand signs such as this, and wiping the nose, other individual signs such as media captions on social media, you posing with individuals who are part of, in those photos specifically, as well as sharing information and communication with other individuals documented as membership with Young Slime Life.
So someone posing in 2 photos with a green bandana, that makes them a member of YSL?
Not necessarily, but the totality of it all. If you're sharing communications with an individual who is documented Young Slime Life, and you're also posing in pictures with individuals who are throwing up YSL in their known territory or around it, and posing with other individuals who are documented as such, yes.
Okay. According to your assessment, was there any physical evidence that I was at 1040 Wiley Street the night of that incident?
I have not reviewed that.
Okay.
Excuse me.
No further questions, sir.
Mr. Hiles, do you have any redirect, excuse me, for Investigator Miller?
Your Honor, is it okay if I said there's just going to be some toggling back?
As long as Ms. Rivers can hear you, that's fine. I'll note you've got a trial partner who could help with the technical stuff. But if Ms. Rivers can hear you, it doesn't bother me. If you probably lying down would be a little too much, but sitting down is okay.
Thank you. Just while we go through some of this Instagram stuff. Okay. Just for you, Ms. Rivers. Okay. All right. Through the course of this investigation, did you go through Mr. Robinson's phone?
I have.
Okay. And did you and I sit down and pull pictures that were on his phone and put them in a specific file?
We did.
Okay. And did we?
I would object to this line of questioning. I don't think counsel gets to open a whole new line of subject matters, and we didn't cover anything about counsel sitting down with this witness.
Okay, but we did cover a whole lot about how are you associating my client with the gang and who controlled the Instagram. It's a different registered user, et cetera. I see Mr. Howes right now traveling in that lane in a responsive way, but let's have a few more questions. And if you feel either it's novel territory, renew your objection. And if I agree, I'll sustain it. Or if it's repetitive of what's already happened, you can certainly make that objection.
Thank you.
You bet. Mr. Howes, you may proceed.
Yeah, thank you. Okay. And were there other photographs outside of what was put in your PowerPoint presentation that demonstrated on different days Mr. Robinson posing with or other gang members or displaying the YSL signs himself?
Yes, there were several. Okay.
And would you say that there was, in the photographs we went through, several hundred photos, correct?
That is correct.
Okay. So I'm going to turn and the screenshots that were up there that said posts of Slim Santana, were those screenshots that were taken directly out of the phone that has been admitted as being recovered from Mr. Robinson?
That is also correct.
Okay. I'd like to go through some of those. And for the record, all of these photos are part of what's previously been admitted as no phone.
Are we dealing with Instagram?
No, we're dealing with
phone.
I'm sorry, State's Exhibit 36.
Okay.
Oh my goodness. No, I'm having no, the Zoom just logged out, but we'll be okay.
No, if Zoom logged out, then we don't get to see the picture. That's not okay. Log back into Zoom. He's just chilling.
Can you narrate a little bit?
I'm sorry, the Zoom, I apologize. The Zoom logged me out when I tried to share it. So I'm just logged back in and yeah, we're going to do that. Huh?
So you listen to what he's saying.
This guy's the only guy in court that has problems with the tech.
Okay.
Here we go. Now we get a picture.
All right. This was in your, but was this the screenshot inside of the Instagram dump? I mean, inside of the phone dump. I apologize.
This was in the phone dump.
Okay. And does this appear to be a photograph, or was this from the phone dump as well?
It was.
And does this appear to be of a different day than the other photographs that was discussed?
Yes.
And what does it say?
It says Happy Slat Day.
Okay. And at the bottom, what does the @ say?
It's a vending name at 1100 block, or sorry, at 1100 baby slat.
Okay. Does this particular picture come from the phone dump?
Yes, it does.
Now he's bringing receipts.
Okay. And this was used earlier, so I'm going to skip that. All right. This particular screenshot, does that appear in the phone dump?
It does.
Okay. And does this appear to be a different day from all of the other, at least by the article of clothing that the individuals are wearing, different from the what we were, the days we were discussing earlier?
It does.
Okay. Okay. Is this photograph from the phone dump?
It is.
Okay. Does it appear to be a different day based off of the clothing that he's wearing than all of the photographs that you used in your PowerPoint presentation?
Yes.
Okay. This particular photo, was that photo contained in his phone dump?
It was.
Okay. And did you also see this particular photograph in his Instagram dump?
I did.
Okay. Now, was this screenshot taken from Mr. Robinson's phone dump?
Yes, it was.
Okay. And what's the significance of all the people that are posted that are in this particular screenshot?
Let's stand up just to see.
You can. Tell me why. I'm confused why this won't work through Zoom. What error did you encounter?
I'm gonna, as soon as we're done with these photographs, I'm gonna go back to Zoom. But I think it will. It just kept, every time I tried to share the screen, it kept popping me off.
Okay.
So some of the individuals depicted in this are documented young Slime Life members, such as Little Got It, Slime Life Shoddy. These are other members. I think the only person who was actually signed to YSL Records or Stone Life Records is Little Got It, and I'm not sure if he actually is. Maybe. But these individuals do create rap music. These individuals have also been involved in several different crimes to range from homicide investigations, shootings, burglary, various other offenses.
Okay. All right. This particular photo, was that photo contained inside of the phone dump?
It was.
Okay. And does that appear to be on a different day from all of the photos we've discussed earlier today?
It does.
Okay. And what is significant about this particular photograph?
The photo the defendant is seen observed throwing YSL hand sign.
Okay. This particular photograph, does that appear to be from a different day?
Yes, it does.
Okay. And what is the significance of this particular photograph?
The defendant is throwing up young Slime Life.
All right. I think I've made my point with these photographs. I do want to go I want to show you, do one exercise here. We discussed the photograph, the one particular photograph that was present in Mr. Robinson's Right now I'm sharing my screen.
Is that a smoke ring?
Just the photograph that you identified as being present in both Mr. Robinson's phone dump, phone extraction, as well as links to his Instagram media.
I have observed both.
Okay. Now, when we go to, I'm going to go to what has been admitted as State's Exhibit 29, which is the Instagram return of Mr. Robinson. For this portion, I'm going to display on the HDMI. So when you go to linked media, and this particular post, I believe, has audio with it.
When you say audio,
that was just displayed as being extracted from Mr. Tyrone Robinson's phone extraction.
Yes, that was in the metadata.
Okay. So if I were to copy the numbers associated with that linked media.
You say numbers, what?
So inside of the linked media, the video that was just displayed said videos, and then it is followed by number 217-197-64-528-6462-3581.
Those are the numbers you're talking about.
Those are the numbers that I'm talking about. Those numbers are those unique to the video posted internally in the Instagram records.
That is correct.
So if I were to copy these numbers associated with that video and then go to Mr. Robinson's PDF, would it show me the time and date that it was posted?
It should.
Okay.
What is Mr. Robinson's PDF?
The PDF associated with Mr. Robinson's Instagrams that are contained in these records. Okay. Would it show the associated time?
It should.
Okay. Let's see if I can. I'll try to. Now that we're not toggling between them, I'll go. I'm now going to share the PDF associated with Mr. Robinson's Instagram. Now I have copied and pasted the number associated with the video in question, and what date does it appear that particular linked media was shared on the Instagram account of Tyrone Robinson?
So this video was posted on November or 11/7/2019, and you can tell that it's a story because it has a take-in time and an expiration time. So Instagram Stories is a live broadcasted story onto the account, and it has a 24-hour long access before it expires. So that is how I'm able to make that determination that it is a story. And it was posted at 15:16 UTC time.
Okay. And going back to some of the questions Ms. Manu asked you, I'm going to stop sharing my screen. Has the music industry in this particular genre of, I guess, trap music, has that proven to be an effective recruiting tool in your investigation of criminal street gangs?
I don't know if I would necessarily generalization it as a trap music. There's like a drill genre of rap that specifically talks about this lifestyle and targeting different rival gangs that is alluring to a lot of the youth, essentially.
Okay. And when you say you look at things in context, not just the signs or the colors, do you also look at who the individuals are that they are posting these pictures with?
I do.
Okay. And someone like Slim Santana, does he have a large following around the metro Atlanta area?
He does.
Okay. And if those pictures were to be posted in a sense of false flagging through his account, what would be the effects of that?
There would be severe repercussions.
Most of the time when you're investigating gangs, are you investigating somebody after they have been initiated into the gang one way or another?
Sometimes it happens. Sometimes I've worked some juvenile cases where I knew that when the individual was jumped in, maybe not initially, but going through a cell phone extraction, I may have gotten a jumped in video or something like that. Worked human trafficking cases where I have seen girls being sexed in, and then that proof or evidence of that initial act of obtaining membership into the gang was then sent to leadership. But there's not like necessarily a database of files that these gangs are typically keeping on record of when this person joined or jumped in. Sometimes there's ledgers. It really depends on the gang itself, but it is very uncommon. I would say it's a small percentage of when I know someone was beaten, blessed in, or sexed in, but it happens.
Okay. In that last video that was played, it was previously been identified as Mr. Robinson with the Song of Young Bands playing. Is it common for members of a gang to promote the music of other members or associates through their Instagram channel?
Yes, it is very common.
That's all the questions I have.
Ms. Mignot, any recross for Investigator Miller?
Yes,
We're going to whisper really loud a little bit.
Okay, so counsel just asked you about photographs that he's alleging depicts different days that you saw Mr. Robinson using hand signs that you consider YSL signs, correct?
That is correct. I don't know exactly what date each one's posted, but most of the photos do have metadata containing each different photo, but based off the different outfits and the several pictures I've observed, I believe they're different photos or the different days.
Now, there's a difference between when I post a photo and when I took a photo, correct?
That is true.
And you don't know the date the photo was actually taken, right?
Of what photo?
Any photo that you just looked at and said, yep, that's a different day. Yep, that's a different day.
It is contained in the metadata of each of those photos, and I can review each one, but I would have to look at each photo and go through the metadata.
Are you telling this jury that the metadata, based on what the state just showed you, is going to tell you the day the photograph was actually taken if it's a screenshot?
If it's a screenshot, no, it's going to depict the metadata of the captured screenshot date. The photo taken, it depends on how the photo was obtained.
Okay, so if we're looking at a screenshot from the alleged phone that is supposed to belong to Mr. Robinson, you can't tell us when the photo of Mr. Robinson was taken, right?
I can tell you based off of a screenshot photo, I can tell you when the screenshot was captured as a screenshot, not when the original of the photo that was screenshotted was taken.
We saw a photo with Mr. Robinson standing at a door, a front door, looks like a home. Did you remember seeing that one?
I do.
You don't know how old Mr. Robinson was in that photo, correct?
No, I do not.
Okay. And that photo could have been taken when he was in elementary school?
I don't believe so.
Could have been taken when he was in middle school?
I would not. He looks of. I have no idea how old he is, but he looks like an adult. It doesn't look like a 12-year-old. Doesn't look like a 15-year-old in that photo. So I would say he's an adulthood in that photo.
How would he have to look in that photo for you to think he's a kid?
That he didn't go through puberty.
Yes.
And I would say he would look prepubescent, maybe shorter, depending on height.
Thinner build.
Like a child. I have
Less
children,
facial
so
hair.
I guess I would assume him to be the stature of a 12-year-old if he was 12.
And sometimes young Black children can be taller or look older than they usually are, correct?
I mean, children are created by God in several different ways. But yes, people can look older, people can look younger. But in those photos that I observed, he looks to be at least in his late teens to early adulthood.
Okay. Now, if I'm in a picture, let's say 1.5 billion times in my life with a Shriner, does that make me a Shriner?
Not necessarily. I don't think, to my knowledge, I don't believe females can be Shriners. But with other sororities, for context purposes, no. Just being in a photo 1.5 billion times does not necessarily make you are something.
So it doesn't matter how many times you look at a photo where Mr. Robinson is holding up his hand in a particular fashion that you think depicts a gang sign, that does not make him a gang member, correct?
Based on my opinion, if I'm seeing several different photos of the individual throwing up hand signs or other identifying signs, to include the hand sign of Young Slime Life, to include wearing a green bandana and posing with other individuals who are members of the same criminal street gang, that is what I look for. Not if it was one photo of the same exact photo 1.5 billion times or million times. That would not be my base, in my opinion. I'm looking at multiple aspects.
What if it's 1.5 billion different times? Would that still make him
if I saw 1.5 billion different photos of one individual throwing up Young Slime Life, I would absolutely think they are a member of Young Slime Life.
Okay, and what if you saw me, a female who you don't believe can belong to a Shriner, throwing up a Shriner sign or wearing something Shriner 1.5 billion times? Would you have that same opinion?
What Shriner sign are you seeing?
Where did you get the 1.5 billion from?
I don't know.
But pretend she is throwing up that Shriner sign now, or they wear the fezzes.
Mm-hmm.
She's got the fez on, but she can't. But she's female.
Being a Shriner myself, I cannot say that I would believe that she would be a Shriner just based on the rules that I know. So I don't believe I would.
You picked the wrong gang, ma'am. I happen to be a member of that
you're
one.
a Shriner.
I am.
If somebody in that group commits a crime, does that make you a gang member?
No, it makes the organization, the Shriners International, look terrible.
Is it because you're a member of it? You think it would make them look terrible instead of making them look like a gang?
No, because Shriners International doesn't make criminal street gang activity. We don't.
But they're all Shriner members that have committed crimes, all right?
I finished my answer.
Oh, I apologize. I didn't realize you were still in it. Go ahead, sir.
I apologize. Yes, I was still talking. If a Shriner commits a crime, that organization, we look bad, and that's something that doesn't make us look good. No one wants to contribute to our organization and do the good things that we're doing. So yes, that would make it look extremely bad.
Now, you are currently employed by the Fulton County District Attorney's Office, correct?
I am employed by Fulton County.
And you're being paid by the Fulton County District Attorney's Office as you sit here, correct?
I am. I'm a salary employer.
Isn't it true that that's the reason why you are willing to look at a photo of Mr. Robinson, and despite him looking like a kid, you're biased, so you're going to make him look like an adult?
Objection.
I don't believe I am biased. I regularly get contacted from several different agencies across the states including defense attorneys, to look at individuals. I have no problem talking to anyone about anything that they may see as a criminal street gang. I also interact with the community, teach at different community outreach events for pastors, or have troubled youth come and speak with me. I also have the parents of these troubled youths ask me questions. So there's no premeditated bias or any perceived bias that I believe exists.
Are you finished?
Yes, I am.
Okay.
It's getting testy in here.
PDF numbers and subscriber numbers and identifiers that opposing counsel just showed you a few seconds ago, if those belong to the subscriber of the phone and the subscriber of the phone is not Mr. Robinson, you have no idea who used those screenshots, correct? Or who made those screenshots, correct?
I don't know.
You also don't know who created the name or typed in the vanity at 1100 Baby Slat, correct?
Whoever the account of 1100 Baby Slat was at the time managing that account and posting for that account is who made that caption.
And you don't have any evidence that it's this gentleman sitting right here, correct?
I have no idea.
Counsel asked you about a Instagram story that you testified was date posted 11/7/19 on Instagram at 15/16/23. Do you remember testifying about that?
I do.
You don't know who put that story up, do you, sir?
I do not.
Counsel asked you about rap music. I believe you talked about trap music. Do you remember that line of questioning?
Yes. I think most of the rap that is kind of being attributed.
So she hasn't asked a question yet, other than, do you remember? That's okay.
Yes.
And I believe you said you're not an expert in music, correct?
No, I clarified that I think most of the music being portrayed by criminal street gangs today is typically drill music, which is a kind of different variation than trap.
But you're no music expert, right?
I have not been tendered in as an expert in music.
Now, you talked about false flagging based on someone who has lots of followings. Do you remember opposing counsel asking you about a rap artist having lots of followers?
Yes.
Isn't it true that most artists have lots of followers?
Depends on what you classify as artist and who, what genre, and if they're, I guess, popular.
Okay, so the only genre the Fulton County DA's office is focused on now is rap?
No, you just specifically stated artists. There's painters, orchestra. I mean, there's singers. There's several different types of art. So I don't know if they're like bird watching is specifically an art, but I can imagine that has crazy followers, but it could. So I don't know.
Okay, counsel also threw up a picture of a male, a black male with a long gun in his hand. Did you see that?
There were several photos of different guns.
There's one where somebody was standing. It's the last photo he showed you where somebody was standing with holding a gun in their hand in the air.
Do you mind showing it to me again? I apologize.
I don't want to depict it again.
Okay. No,
so you don't recall who's that male in there, correct?
I don't remember.
Okay, and you can't say that male's my client?
No, I can't.
Okay, nothing further, Judge.
Finally, any recross from the accused?
Finally, says the judge. The state is about to rest if we don't have any more redirect. Redirect.
As an artist manager, if I'm doing business with individuals, I would call my clients and artists who you have assessed are gang members. And my job is to overly support my artists by by means of taking pics with them, joining in their music videos, and even going to their hometown to visit their friends.
Object. It's not a question.
It's going to get, I hear a question mark coming soon.
Might have been a long question, but I do want to start over just so you understand it.
He got it. So you're the artist producer, you're in pictures, you go to the hometown.
Pictures, going to the hometown, even, being acquainted with their friends and getting to know their friends and their life. Could I,
here comes
with that, just with that support that individual, as an artist manager can put out toward artists like that, could I be mistakenly indicated as being a gang member just because of my support, my overly support of an artist?
I'm sure someone can mistakenly identify someone who's not in a criminal street gang as a criminal street gang by being associated in that kind of capacity. And that is why I think it's so important to understand why it's not illegal to be in a criminal street gang. It is illegal to commit to being a criminal street gang and commit criminal street gang activity.
Okay. Everybody that you have assessed to be in YSL, just based off of your knowledge right now, could you find at least one piece of evidence of each of them throwing up any type of YSL hand signs and or using any type of YSL verbiage?
Yes, I have worked several YSL cases involving several YSL members, of them throwing up YSL hand signs, them saying the terminology. Yes.
This is the accused, Mr. Pritchett.
And you have no evidence that you've ever seen me throw up a YSL sign, correct?
I have seen YSL signs such as a green bandana and posing with individuals who were displaying criminal street gang hand signs of Young Slime Life. Yes.
Have you ever seen me throw up the YSL hand sign or any other form of YSL hand sign?
I don't believe I have.
Have you ever seen me use any of the YSL verbiage or lingo?
I don't believe I have.
No further questions.
Questions from the jurors for Investigator Miller.
He got his mic drop moment. There's one question.
Questions from the jurors for Investigator Miller.
Did it skip back?
Yeah, they do. They've already written them. Some of them had 3.
Thank you. All right, ladies and gentlemen, quick break for you. Jury room, hallway, no outside research. Don't talk about the case. See you shortly.
As the jury heads out, this should be quick. We'll review these questions between the two sides. I expect that at the end of these questions, first of all, the judge will allow each side to ask a few more questions to clarify some of the answers or the testimony that's brought up in response to the jury questions. After that, the state's going to rest. We're going to have a break.
All right, Mr. Hiles, come on up here.
It might even be a break for the day.
Get these, share them with Ms. Mignot and Mr. Pritchett.
I took a power nap during that last little bit, but I was listening the whole time. My ears didn't go to sleep. I just rested my eyes.
2 more. You just swing right back here. Sorry, I just hadn't read them all. Go. Thanks.
Lots of questions. Okay, if somebody asks a question about the witness's hair, what's we all get bingo, right? ASMR from the judge. Takes us back in the day. No white noise. The problem they have here is they have a pro se defendant. And pro se defendants can't go back into the judge's chamber, or they also are not really supposed to approach the judge. They don't want to be. Judge doesn't want to be really close to him, and so they have to figure out a way to let him review the questions, which he has the right to do as he's acting as an attorney, without the jury hearing everything. And so they have the jury leave. That was the easiest fix.
After Mr. Miller's jury questions, do you not want to brief question here?
So my thought is, if you're resting, I have to give everyone a break anyway. And so we'd start with a quick break, because then we have a bunch of things to talk about. Can you wait till then?
No, that's my plan.
Okay.
That's my plan. I just
okay.
Got a long time.
All right, Mr. Hiles, did you have any objections to any of the questions?
No, Your Honor.
Ms. Mignot?
No, Your Honor.
And Mr. Pritchett? Okay. Let's bring the jurors back in, work through these.
Get all the questions.
Wrap it up. Sorry, I'm not going to ask the one which says, why do you suppose, like, what's your theory behind, that's speculation.
Which one was that?
Why do you suppose gang members still use social media?
Okay.
Haven't they learned?
I think he would have personal knowledge as to why they do use social media.
But that's not the question.
Oh, he can give.
You could, if you think it's proper follow-up, you can go there.
All right.
He's an expert, so he is allowed to speculate. Got about an hour and 15 before we hear about the Kelly trial. See if we get if that's going to be retried or not. We'll try to bring that to you live.
And can you please have ready the photo of Mr. Robinson with the green shirt with a smiley face and the gun in the waistband?
Yes.
I think it's actually the slide that has the 3 photos.
I'll have it ready.
Thank you.
What's the holdup with the jury? They took a long break, I guess. Do we have to get off social media in our gang? I guess we can't be a gang after this testimony, because he says part of having a gang is we have to commit crime, and we don't do that. So what's the step down from gang? Do we just call ourselves a collective or an organization? Maybe we could be like a group, a support group, a club. Cult is in there. That's an option. It's got a little negative connotation to it. We're a club. We're a group. We're a posse. Posse is good. Because posse could be like, the sheriffs have a posse, right? A squad. Police have squads too. We could be Shriners, apparently. Okay, jury's coming back. I'm so excited for when my bathroom's all done and I get real sleep. Like, I sleep the whole night long and don't have to get up and work in the middle of the night. It's just that is just going to be a good day. I think it's going to be this week. Chat is full of word.
Thank you, Deputy Gordon. You all can be seated. Investigator Miller, you were asked or discussed some young stoner life as opposed to young slime life, and referenced it being a music label or some type of business. Explain to the jurors how you could describe that. I don't remember your words. You can use your own. Legitimate business, credible business, if it is closely associated with something that you're describing as an illegal enterprise, as in young slime life.
So, Young Stoner Life, it's a record label. They do produce music. That's legal. Essentially, the music videos that they're making, as long as there's no crime being committed or an album, that's legitimate. So if they take profits of that from Apple iTunes, from concert venues, that is essentially clean money. The criminal street gang will often may be involved in both, such as also making music, also profiting from music, but also selling narcotics or committing violent crimes.
Do you have a sense, or can you estimate how many of the photographs, images that were recovered from the cell phone extraction of the phone that the state is contending is associated with Mr. Robinson, how many of those were photos taken on that phone, as in I hold up the phone and press the button and it's a selfie, or it's us, the jury, versus screenshots of, oh, I'm surfing the internet and that's a cool picture, I'm gonna grab that picture. I didn't take it, but it's found on my phone.
I can't give like an accurate percentage, but most of the...
Then we would object to speculation.
Okay, so if you, how about this? Sustained, objecting to my question. Were there both on the device?
There are both.
Okay. Mr. Hiles, if you'll put up the image or images we discussed during the break, please. And this should be on your screen. You shouldn't have to crane on the other screen.
Thank you.
Here we go. We all get to see it. The judge sustained the objection to his own question. That was rare.
So the question is about the firearm that is in the waistband of the person you identified as Mr. Robinson. One, can you tell simply from looking at the photo if that is a real firearm? And then two, regardless, real or not, would you characterize that as a mini AK or a mini assault rifle type gun?
Based on these pictures, I can't tell if that's a prop AK variant type firearm or a real one. It does resemble a AK variant, what commonly referred to as a Draco, a small AK rifle. These firearms are commonly chambered in 7.62.
Explain to the jurors how someone becomes what you've referred to as a documented member of a gang.
So it depends on the individual. I'm looking for, once again, several different identifying signs. So I'm looking for, is this individual throwing up hand signs? Have they given a self-admission, whether it's in an interview room or on the streets? If another individual, another member says that this person is a member, or like another person is a member or another member, if they identify leadership, if they deny any of it and we find evidence and say their cell phone or their Instagram records, or sometimes we do search warrants and we obtain gang writings in their house or their room, children, sometimes book bags and like note writing and stuff like that. Some gang members also tattoo themselves. So there's several different identifiers that I look for, but I'm never just looking for one. Not necessarily even looking for two. I'm just looking at everything that I have collectively do I personally feel comfortable saying that this person is a member of a criminal street gang, or are they associated? An associate, I'm not really looking for if that individual is throwing up certain symbols or something, and I'm looking for it, but if I don't see it and it's not apparent, but they are committing crimes with individuals who are documented, then I feel comfortable saying that they're associated. Then we have different law enforcement softwares throughout the states. We have a GBI gang database, which is typically more for documentation of security threat group members, also known as members in Department of Corrections who are validated members. So that would be one form of documentation. Another documentation would be like a gang profile. So different images, pictures, or reasons why that gang investigator would think that this person is a gang member. Those are the classifications of documentations.
From your knowledge and experience, what would you estimate the size of the YSL street gang to be? Size meaning number of members.
It's a lot. I would definitely estimate it in excess of 20 members for sure.
How many members of YSL have you interacted with in your professional capacity?
Well over 20. That's why I can say over 20.
You referenced a couple times someone known as Young Bands. Is Young Bands, do you believe him from your experience to be a member of YSL? And if so, is he a documented member of YSL?
I personally haven't documented Young Bands, and I personally haven't done a criminal investigation independently into Young Bands. But I have seen documentation of Young Bands being associated at a minimum with Young Slime Life.
Mr. Hiles, do you have any questions for Investigator Miller based on that exchange?
Yes. We talked about AK, mini AKs being Draco or chambered in 7.62. Are those guns that are popular on the streets of Atlanta with gang members?
Yes.
What about YSL?
Yes.
Okay. And as it pertains to the Street Gang Terrorism and Prevention Act, does it matter if somebody is documented as an associate or a member if they are committing crimes in furtherance of that gang?
No, it can be either or. It can also be employed by.
Okay. And we talked a lot about what was pulled off of social media. Why is it that gang members are still using social media when it's being pulled as evidence against them?
Well, what we often see is sometimes they will remove social media from an account. Sometimes they will go, if they think they're being watched or investigated, their account can be changed to privates, or we'll see that they erase things. In my experience with investigating criminal street gangs and social media, we had to typically get a preservation request submitted into Instagram or Facebook or any of the social media accounts fairly quickly, because once an individual thinks that we are investigating for their crime, that's when they start wiping everything and things are getting deleted. The preface of that, if they are, before they commit crimes or even after, some members don't. Sometimes they brag about it on social media. Sometimes they're trying to gain even more notoriety in their criminal street gang. And I've worked investigations where individuals are calling out specific individuals of rival gangs of who they're going to target, and then
at the bottom
broadcasting
right, it says,
it for everybody to see, not privately.
I would object. The witness is non-responsive.
Do you want to focus the answer, or do you think your question has been answered and you're ready to move on?
I think my question has been answered.
Okay, next question, if any.
No other questions.
Ms. Mignot, do you have any follow-up?
Yes, Your Honor. As it pertains to
this back and forth should be narrowing the scope.
question about
questions.
The phone, Instagram records, children noting, writing, tattoos. In this situation, you are using this photograph of our client and the music video to determine that he is a member of YSL, correct?
I'm using several photos and identifying signs. So I'm looking at the totality to include music videos.
Okay, so let me re-ask my question a different way. Despite the number of photos you're using, the two identifiers you're using are photos and a music video you found on YouTube, correct?
No, my identifying signs that I'm looking for to make my assessment have been hand signs, various hand signs, the wearing of bandanas, posting and sharing with individuals that have been documented with YSL, as well as posing and shooting music videos in known YSL territory and promoting the YSL criminal street gang.
Okay, so this picture of my client in the hand sign, check one, right?
So there is one hand sign right here where he is throwing up for YSL while also wearing a green bandana and standing next to individuals who are armed with suspected firearms, throwing up hand signs of YSL. That's several identifiers. That's not just one, that's multiple.
Okay. Counsel, could you cue guns up, please?
Oh, here, let's turn the video off.
Yes, I am. I got to get it from up here.
If you'd like to. We're going to play our music again because we're not going to get hit for a copyright on this one.
States 39. We're going to show you States 39 just as soon as we get it up and running.
Okay. Are we playing the whole thing, or there's part of it that you?
Only a small portion, Your Honor.
Okay. And that's HDMI land.
It is.
Okay, we're ready, Your Honor. I've got it queued up.
Guns up is what you wanted? Okay. Okay.
We have to back it up.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection.
Can you see what Mr. Robinson is wearing in that video? Okay. Okay, and he's wearing the same bandana in the exact same spot that you have him in the picture that was depicted in a still shot on the street, correct?
That is correct.
All right. He also is wearing the same shirt.
That is correct.
Okay.
T-shirts of murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells all rise and pay respect to the
I don't know. I'm trying to get the questions.
and only go to true crime. Imitators they try, but they just can't achieve. And
he's wearing the exact same outfit that you have in the still shots that you said you weren't certain if they were from the same day, right?
That is correct.
Okay. Can you tell now from looking at the video that he was wearing the exact same outfit and that the pictures that you have in the still shots are just different angles of him from this video?
Yes, I agree with that. Earlier, I just stated that I did not personally crop photos from YouTube and posted them on the PDF file.
Okay, so somebody else cropped these pictures that we were looking at for you?
No, there's your pictures, and then there's a video. You asked me if I had made any type of clippings from the YouTube video, which I did not. I located those photos in the phone, and those were uploaded into a PDF. Those aren't clippings, those are photos. So a clipping is like a snag it or a clip it aspect. I didn't take any clippings from the YouTube video as far as I only did a video recording.
Okay. So if the pictures that is depicted in what we were just looking at is the exact same day of this event and someone was just taking screenshots of it, you would count that as one encounter, right? One gang member affiliation encounter.
No, I saw several identifying signs in this video. There were several in the
But the
video.
event, if you ended up with 5 still photos on a phone, on Instagram, that were all taken from the event of filming this video, and there may be 97 different identifiers in there, but that is one event. Do you agree? One day, one part of a day.
If I saw multiple identifying signs from one day, yes, I would feel comfortable identifying someone as being associated, a member, or depending on the identifying signs that I saw.
All right, so let's talk about the evidence in this case. Thank you so much, counsel. I appreciate it. The evidence in this case that you are looking at, based on what this juror has already been presented, is the exact same clothing on the exact same day with numerous identifiers, as you would say, correct?
They've also been shown several other photos from different days of different identifying signs of membership of Young Slime Life.
Okay, so let me go back to my original question. Photographs you used, correct? Photographs you used.
I have used photos.
In this case, as an identifier for my client as a YSL member, correct?
I have reviewed photos of him displaying identifying signs of Young Slime Life.
Okay.
Yes.
And you used photos and you used video, the rap music video, correct?
Yes, I reviewed music videos of him displaying identifying signs of Young Slime Life.
And based on the video and the photos, you have determined that our client is a member of the YSL gang, correct?
Yes, along with other evidence.
Nothing further, sir.
Any questions from the accused based on the questions I posed to Investigator Miller?
Yes, ma'am. Do you have any evidence of pictures or videos of me ever holding a gun?
I don't believe so.
What are the colors of YSL? Is it one color or is it many colors?
So they'll commonly use other colors as well, but primarily for specifically YSL, it's green. However, if a member is sex, money, murder, and also a member of YSL, they may utilize red and green. Whereas a member who is a neighborhood rolling 60 Crip, for example, their primary national affiliation would be blue, so they could use blue and green. But green is the specific identifying color for Young Slime Life.
So it could be green, red, or blue?
Yes, depending on the individual.
He's like, oh, didn't know that. I thought I only had the one option. Could it be like a bright orange?
Based on what you said your indicators were, I could be mistakenly indicated as a gang member just by on 1 or 2 occasions hanging out with other people who are indicated as gang members.
It depends on the circumstances, but it really just depends on the circumstances. If you're just hanging out with individuals who are, I don't know, your family members, not necessarily getting documented by law enforcement. However, if you're stopped as a suspicious person and there's drugs or something, maybe you don't get arrested, but someone else was arrested for something, that could be a scenario where someone kind of documents something or starts documenting something. But what that individual investigator does to identify that individual is not me. So I don't know. It would have to be what I saw and what I documented.
So the indicators that you saw and documented to assess me as a gang member were picture of me holding up green flag Another indicator that you saw or was pictured was me being in the supposed territory of this gang. Picture that you also do not know the context of. And the other indicator was, I believe you said that I was associated or in communication with other supposed gang members. And if we take that assessment with the lack of evidence of me ever throwing up any of the gang signs, and the lack of evidence of me ever using the YSL verbiage, don't you think your assessment of me being a gang member is greatly weak compared to your other assessments?
No, I think it's very strong based on the holding up a green bandana with other individuals who are throwing up Young Slime Life, who are on the territory, who are commenting or posting the same terminology. I think that's very strong gang evidence.
Even knowing that I never threw up those gang signs or used that gang verbiage.
Yes, because I look at it as acceptance. So if I'm with a criminal street gang and I'm a member of a criminal street gang and I'm with criminal street gang members and they're posting and saying something and I'm doing the same thing with them, but I didn't say anything, that is an acceptance, an accepted admittance, so to speak. So if they're accepting the same what is being broadcasted on social media or video.
So that's acceptance and not just support. If I'm a manager and
I would
supporting an artist,
don't interrupt him.
I would agree with you. That is supporting
that person as an artist, not what they're doing or saying, but supporting them as an individual creative artist.
Yes, I would think that would be supporting as both.
Okay. No further questions.
Thank you, Investigator Miller.
Thank you, Your Honor.
You can step down.
We've been waiting for these words.
Mr. Hiles, next witness.
Your Honor, the state rests.
Boom.
All right, ladies and gentlemen, it is time for a break for you all. As I forecast, when the state rests, there are a number of matters I need to take up with the state, with counsel for Mr. Robinson, with the accused. It's going to take a few minutes, so be at ease, and I will bring you back out here as soon as we are able to continue and see if Ms. Mignot is going to present any evidence on behalf of Mr. Robinson, which she has no obligation to do, and see if the accused is going to present any evidence on his behalf, which he has no obligation to do. The fact that the state rested does not mean that it's time to begin your deliberations. There may be more evidence presented, there may not, but that still doesn't mean it's time to begin your deliberations. We have closing arguments and the charge I need to give you at the end of the closing arguments. So no outside research, don't talk about the case. We'll get you back here as soon as we can.
All right, let's do it.
3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 13.
All right, Mr. Hiles, how much time do you need on this break before we can talk about what we need to talk about?
Just 3 or 4 minutes.
Okay. Ms. Rivers, if we take, I can't remember if you got a break the last time we took a break. We didn't. All right. Let's be back here at 3:50 to on your phone time to talk about what's next.
Can I set my timer for 20 minutes, Your Honor?
3:50, 3:50. That can't be 20 minutes from now.
Is that 15?
That's 10 at the most.
All right, so I will set it for 10. I will not be late.
Set it for 9. Okay. I don't know what math you're doing.
All right. So I do hope to have some big deal merch available for those who have asked for it, I'm not saying this will be our colors or anything. Obviously, when we talk about forming a gang, we're joking. We have no criminal enterprise going on. We're just a bunch of friends having some fun. But the record label though is a thing, so we're moving forward there. Let's see. In the pickle jar of life, you are the big deal. I like it. I like it. So everyone's off to talk to their clients. The big thing that the defense needs to talk to their client about is, do you want to put up a defense? What's our decision? Are we going to start calling people? Will it help your case if we call people, or will that, make it look bad because they'll get asked questions as well? And the accused gets to decide for himself. Do you want to testify? There's been a lot of times during this trial that the accused has, Mr. Pritchett, I'll call him that Mr. Pritchett has wanted to say things and been unable to bring it in. He's wanted to ask questions in a way where he could tell something. He's able to do that only in two ways in this trial, and that is to testify as his own witness in his own defense, and he would probably be allowed to speak in narrative form instead of asking himself questions. It just looks weird when you're pretending to be two people. But he may do that. I think that's the riskiest move because he already has the option, even though the juries will be told this is not evidence they shouldn't consider it as such, but he has the option at the end to give a closing statement or closing argument where he gets to put everything together, and he'll have some latitude to be able to put things, to tell the story that he wants. So I think if he's smart, he does not take the stand. Because that could open up, honestly, with how close we came to the door being opened, I think he might blurt something out on the stand under some artful direct examination or cross-examination from the state that could be a problem. So hopefully it does not take the stand. That would be very detrimental to his case. As far as Mr. Richardson's goes, I think he's got some talented lawyers who can give him some good advice. He probably also will not take the stand. That means that unless they start calling witnesses, which Mr. Pritchett says he's got a few that can be here tomorrow, there's really not a lot to do this afternoon. So I'm not sure if Mr. Richardson's going to call witnesses or not. Not part of the Pickle Gang. I'm just here supporting the artist Big Dill. Someone was asking me if they can get that song on Spotify. I don't even know how to get something on Spotify. So somebody has to tell me. Clearly, my record label is not supporting my music the way they should, because I thought that was something they would take care of. But we'll see. I cannot wait. You guys, I'm giddy inside when I look at the great lyrics we have for round 2 of our rap songs. It's so good. It's so good. The play on words, the artistry that's involved is top notch. It doesn't get much better than that. Can we take a poll on whether Mr. Kelly will be retried? Well, let me do this because Mr. Daybell is done for the day. I can use that computer for this. Let's see if I can find. We are watching for a live stream, and I haven't seen it yet. Okay. Keep an eye on some of the news stations in the area. We're good there. Oh, good news, by the way. I forgot to tell you this morning. And Reverend Beasy, I credit you for this because you've got the internet and you're making it all work. But my little SSD drive, the storage drive with the cloud dock, fixed it. Got this cable, which is the one I needed right here. It's a little USB to ATA cable. and was able to reset up the drive. And now I can record for, I think I can record for nearly 2 weeks straight of court just on that one drive. And it's recording right now just as a test. And I've been able to link it to multiple devices so they can play back while it's recording. We're getting there. As soon as the keyboard comes out, which should be next month, we'll start having some replay capability. KVOA says the hearing is 1:30 local time. I'm hearing that. I've got KVOA is one of the stations I'm watching for. If you've got a link to something that I don't, that would be great. But let's see, news. I don't see the Kelly trial. Let me search for it here. What are you guys seeing? How do you guys see that? Okay. Okay, I'm not finding anything. I don't see any links to any live streams for the Kelly trial. If somebody has something, send it to me. That would be great. And then let me know where to look for it. Live. Click play on that one. Just let it roll. Okay. I'm thinking that it's not going to be retried. That's my take. Just the 7-1, the odds are just not there. You can use another site to disassemble the song into its parts or make it instrumental to sing to. Jim Bob, send me the links of where to do that. I'm brand new to this recording industry. I've got one tool and it's not doing what I want it to do. Try to slip in my gang name, Hot and Sweet. Greg. I want to make one. Well, the prosecutor just gets comfortable there, sits on the desk. I want to make one that pays tribute to a lot of the people in LawTube. Friends of the channel, all the way through the pillars of LawTube. Not as like disrespectful, but just like a LawTube rap is what I'm working on. It's only 12:47. They've got 45 minutes. Usually within 15 minutes is when they get the live stream up. Yes, we're affiliated. We're adjacent. which is a word it really doesn't fit in many raps. I tried to put a law tube adjacent in there, but it just doesn't rhyme with a lot of stuff. Okay. My family listened to your song all weekend. I think I've got 7. I went out to the app, okay, and this app that Courtney used and that I used to make the song, it lets you make 10 songs a day or 10 songs a month. I forget what it is. And so I paid, because then I now get to make 250 songs a month or something like that, because I have 2,500 credits and maybe it's 500 songs. I forget. Anyway, so I'll see if I can put Phil in there. But does he want to be TYO Toys or Tio? Because this actually works really well. Because toys and boys, it works. Because I'm ambitious. 10 a day on a freebie. Okay, so I made probably 50 versions, just tweaking the lyrics, getting the timing right, and of course half the time it makes a song that, like, some of them it was straight on explicit lyrics right at the beginning. It just starts yelling words that were not in my script. I'm like, okay, well, I can't play that on YouTube, but so I had to report those ones. And she's very patient, but when she exercises, she doesn't listen to my music. Let's put it that way. Oh, I've got there's so much good stuff, Pam. I wish I could. I don't want to tell you because I don't want to spoil it. I want you to discover the hidden gems that are in the lyrics, buried in the lyrics. Double meanings and it's gonna be wonderful. "30 minutes to the Kelly decision." I'm watching right now. I'm watching KGUN and KVOA for information on that one. I'm not seeing either one saying much at all. So if you see something, let me know. Adjacent and complacent. You can edit songs on Fader. I've never heard of this before. AI stems and remixes. I was looking for a well-known song that even I would lose like monetization on, like something like Adele, that I could like do a mix with Adele or Taylor Swift. So I could blend the songs back and forth, so it sounds like we did a collaborative, but just don't have that. We're working on it, Melissa. We're working on it. It's next in line after the bathroom. I've got so many sample songs that were sent to me, and some of them are just amazing. They're really good. Just Jenny. No, I'm sorry to let people down here, but we hired Snoop Double G. No, we didn't. We used a computer. It's a computer that's singing the song. Melissa, I'm trying to not drink Mountain Dew unless needed. I need it right now, but I don't have any, so that helps. T Swift has some good songs out on the Tortured poets department. Yeah, we're going to, Rob will be in there. Peter will be in there. Probably EDB. I don't know. We might get Uncivil mixed in. I need a tool that's better than Suno because I need more verses. And Suno only gives me 2 minutes. We're only going towards rap music. Just, yeah, for right now. But we can change it. I tried to make a country music one. Just did not sound the same. When the Kelly hearing starts, yeah, if we get a live feed, we'll pause this and jump to Kelly for sure. Oh, Brandy's already worked in. Runkle, got it. You guys, I tell you, I've been working on nothing else. Well, the bathroom and this is all I've been doing all weekend. What song? And I'm thinking I'd prefer it to be like a female artist with a well-known song that's more of a pure sort of sound as far as melody, something that's maybe haunting, a little simple in the words, and then mix in alternate verses with rap. So what song do I mash up with? Taking suggestions. You can click extend a song by hitting extend, then you can click get whole song. I extend it, but it won't let me add more words. Like I've reached the maximum words it will allow me to put in, and so I just get music on the end. Or sometimes it starts like throwing all the words in a blender and going back over and over and over the same thing. Like a Billie Eilish, maybe? Duh. No, not that one. Not the duh song. Tug is where we got this idea. Tug already has his intro music like this. Maybe Heart. Superstar. I was thinking either like a love song. Okay, because I really want, like a pure something that everyone's heard type song, or there's no audio yet. They haven't come back from court yet. We got a bit. Thomas, what you sending me? I saw that just briefly. Thomas, did you make this song? This is Thomas's song. I already know. I'm impressed. Okay. I'll have to listen to this in high fidelity. All these songs you're suggesting, I have to listen to them, but I can't listen live. Willow? Shannon. I am most definitely not a rapper. We just have fun with this. I can be the voice, but I need the tool to be right. I need it to be right, and I'll probably need to mix it up a bit. We're going to fit Dr. Joe. I'm not sure if he wants to be dragged into this. Gotta know when to hold 'em. That's a beautiful song. Love the story on that one too. Madonna from the 80s. Two Become One, Spice Girls. Good suggestions. I've got to listen to all these. Tennessee Whiskey. I don't know why they aren't giving us audio. But the court isn't back. The jury's not back yet. I think they're doing a little discussion about some things right now. Audio's up. We're just not hearing anything. Lady Tammy, state just rested. We're in a we thought it was an Airbnb home invasion robbery case, but it turns out to be a gang education case. She might be doing a JOA, possibly. So it's defense if they want to. They have no obligation. I call it the podium. It's actually the lectern. Podium usually means a stand you stand on. A little Bon Jovi, maybe. And let me check out YouTube Studio. What would happen if I were to use a Bon Jovi song in my live stream? When you're, okay, let me say this. One of the benefits of being a partner, a YouTube partner, is that, let's see, let me go here, that they give you access to songs, and they actually can tell you what you can use and what you can't, and what would do to the rights if you use it. Nothing on George Kelly yet. I think we've got another just under half an hour before we hear anything from there. No audio right now. We're waiting for them to turn the audio on. I think they're still on break or they're arguing the JOA. Let's see. Dead or alive? Let's see. The terms of this. I could use Bon Jovi's Dead or Alive. Using this track will not affect your video's visibility, but it will make it ineligible for monetization. Shorts monetization will not be affected. So I could use Bon Jovi. He would get all the money. A lot of them will do revenue sharing up to 30 seconds. So we got Tupac and Snoop Dogg, Dead or Alive. Gin and juice. That doesn't really go with the theme of the channel very much, Maisla. Is she practicing? Is she practicing her lines? Because the prosecutor's just kicking back. Gangster's paradise. They're spending all their life living in a gangster's paradise. Mariah Carey, We Belong Together. Let's see.
because you have a duty under the law of
just got audio.
Liberty versus State. And it says the trial court has a duty to grant the motion if there is no conflict in the evidence.
But you created a conflict in the evidence by impeaching them. But it's not my role to say your impeachment was so effective that these witnesses are entirely unbelievable. And it wasn't. I'm going to find if the jury convicts that there was a basis for them to do that because you did impeach them. But I don't believe that those two witnesses are completely without credit. So the jurors are free to consider that testimony with all its contradictions, internal and imposed through your impeachment. Lavertu, no case in the annals of history of Georgia appellate law says because the defense attorney says, hey, I impeached this witness, I have a duty to say, oh, okay, then I need to grant a directed verdict.
No, because that would be a mischaracterization of my statement. My statement is you are authorized by law to grant the motion for directed verdict if there's no conflict in the evidence. In terms of count one requires that make an unauthorized entry into a legally occupied dwelling. There's no evidence before this court that Mr. Robinson made an authorized entry. And the reason is no one said they saw them go in. No one said they saw them come out. And that's Riley and Kalish's testimony. And I went over it ad nauseum.
That's accurate. So you're ignoring circumstantial evidence. And that's what's going to trip you up, at least on your motion for directed verdict. You may be able to convince the jurors that the fact that no one saw it happen means he didn't do it. But there is ample, let me put it this way, there's more than enough circumstantial evidence connecting your client to the home invasion and armed robberies and aggravated assaults and possession of a firearm during the commission of a felony. Circumstantially, he's put in the car by Riley and Kalish. He's back in the car when they're in it. They, Pritchett and Robinson, have stuff they didn't have before. And we know some of it belonged to the people who were in the house. So it's not direct evidence, but it's circumstantial evidence. And I'll be telling the jury that they need not concern themselves whether direct or circumstantial as long as they don't have reasonable doubt about what happened. I don't know if they're going to have a reasonable doubt. That's not the test right now. If there's no conflict in the evidence and the evidence as it stands demands a verdict of acquittal, it's not that I'm authorized. Like you said, I have a duty. I must direct a verdict as of that count. And that's true for one of the aggravated batteries, but it's not true for the home invasion because impeached testimony doesn't mean discredited by the jury testimony. Otherwise, the moment someone impeached a witness, like, okay, we're done. I guess the state loses on this one because they didn't have an unimpeachable witness. That would be curtains for almost every state prosecution.
It wouldn't be that, Judge, because in those circumstances, the state usually will have circumstantial evidence to substantiate the claims of the co-defendant, such as we found fingerprints. We checked the cell phone towers and we found the cell phone tower placed the person at the scene. That is not the evidence that is before this court. So we don't have any cell tower placing our client at Wiley Street, the location where that was. We have testimony that neither person, not Riley, and I'm only speaking of Riley because we already passed whether the victims can identify anybody or not, because that's clear. Neither Riley nor Kalish said that my client made an unauthorized entry into the property. In fact, I believe Kalish's testimony was, I don't even know if it was Rick Rare or Baby Slat that made entry into the property. And that is her testimony in court, not in her first interrogation, not in her second interrogation. So I don't know what circumstantial evidence the court is using or referencing when the court is saying that element number one is met by the unauthorized entry into a legally.
Two people made an unauthorized entrance into that house. Do you agree with that? Or you think that there is no evidence, there's no conflict in the evidence that two people wearing masks and having guns made an unauthorized entrance into that house?
No, I'm not arguing that. That's what the victim said. Right. So if we bring the victims back into this case, then the answer is yes. The two.
Right. You can't exclude some part for your argument and then bring it back in. What has been, I think, established very clearly is that there were two armed, masked gunmen. No one said it was a woman, and people have explored.
One did. Hooper, go back and look at it, Judge.
Then there's a conflict in the evidence. Keep in mind the standard. There's a conflict in the evidence. I don't think Cooper said it was armed, masked women, but if he did, That's just conflict in the evidence. There's evidence that 2 armed masked gunmen went in the house. There are 4 people in the Mercedes, then there's no one in the Mercedes, then Riley's in the Mercedes, and then she said, who ran in? She didn't say the people who ran back into the Mercedes are people I didn't know. She said the people who got back in my car were Rick Rare and Baby Slap. So it could have been that they went to a Wendy's to get food, but that's not what the record establishes.
So I just wanted to be clear for the record that the court believes that there is circumstantial evidence that unauthorized entry was made into 1040 Wiley Street by my client on November 8th of 2019.
Correct.
Okay. And can the court say what that?
Not my job.
Okay. Okay. The second issue is with the intent to commit a forcible felony therein. I do not believe that there's any evidence before this court that my client, 1, entered, or 2, intended to commit any forcible felony therein. In fact, we don't even know if there are more than just the 2 females in the car as we stand here today.
The only way you wouldn't know that is if you're choosing not to credit their testimony, and you're free to not credit their testimony, but their testimony was 4 people in the car, your client, Mr. Pritchett, and the 2 females.
Right, but we cannot discount their interrogation where they said they were the only 2 people in the car. But if the court is saying that's a conflict, we'll make the argument. We can understand the court is not.
How is it not a conflict?
All right, so may I proceed, Judge?
Yes, please.
I don't want to waste the court's time, and it's clear we're not going anywhere with count 1. As it pertains to
about that.
Count 2.
Okay, we're lined up for the live feed when it happens. We've got the connection.
The record is void of any evidence of Mr. Robinson, once again, entering the Wiley Street property. Count 2 is armed robbery as it pertains to Holden Carmody and a wallet. Mr. Carmody testified that he doesn't know who took his wallet. There was no testimony from Ms. Riley or Ms. Kalish, if we focus on just those 2 individuals, that Mr. Robinson was in possession of Mr. Holden Carmody's wallet. As it pertains to count 3, the robbery was regarding Christian Hooper's wallet. According to the indictment, neither Kalish nor Riley testified that Mr. Robinson took a wallet from the person of Mr. Christian Hooper, and we submit to this court that directed verdict is warranted under that count. As to count 4, this is armed robbery for Noah Walker cell phone. Mr. Robinson was not found with a cell phone. There was no testimony that he took a cell phone from either Ms. Riley or Ms. Kalish. As to count 5, armed robbery, Rebecca Mears' cell phone. There was no testimony that Mr. Robinson took a cellular phone for Ms. Mears, or from the person of Ms. Mears, or from the immediate presence of Ms. Mears. Directed verdict is warranted on that count. As to count 6, Jackson Buckingham, his shoes. There was no testimony that Mr. Robinson took from the person of Mr. Jackson Heil. I think he's Jackson Buckingham Heil, Your Honor. He's listed as Buckingham in the indictment. He testified he's Jackson Heil. So there's a conflict in the indictment. We'd ask for directed verdict on that count. As it pertains to armed robbery, Vikyat Gatani, a wallet and a cell phone is what the state alleged that was taken. And we submit to the court that there was no testimony that Mr. Robinson took, not from Ms. Riley nor Ms. Kalish, a wallet from Mr. Gatani or a cell phone from Mr. Gatani. There, count 8, Christian Riggs, a laptop, computer, keys, and wallet is what the indictment states. There's been no evidence in the record or from Ms. Kalish or Ms. Riley that a laptop computer was taken by Mr. Robinson from the person of Mr. Riggs, or that keys of Mr. Riggs were taken, or that a wallet was taken. As it pertains to count 9, aggravated assault with a deadly weapon, there is no evidence before this court that this is a count regarding Mr. Holden Carmody. There's no testimony or no evidence in the record that shows that Mr. Robinson assaulted Mr. Carmody with a weapon or pointed a weapon towards Mr. Carmody. Not testimony by Ms. Kalish nor Ms. Riley. As it pertains to counts 10, aggravated assault with deadly weapon, that is against Noah Walker. In fact, I believe Mr. Walker was the person who said that he passed out in the middle of the events, and he had Asian glow, first time I've ever heard the term, and that he was out of it. He doesn't know what happened that evening, and there's been no evidence to submit that Mr. Robinson, with the intent to commit an assault upon Mr. Noah, pointed a gun towards Mr. Noah during the robbery that took place November 8, 2019. As it pertains to count 11, the aggravated assault with a deadly weapon was regarding Miss Rebecca Mears. Ms. Mears testified she doesn't know Ms. Kalish nor Ms. Riley either testified that they saw Mr. Robinson pointing a weapon at Ms. Mears.
I wish I knew why she was limiting her argument to just those two testimonies.
Count. As it pertains to count 12.
Because the conflict.
I apologize. Yes, count 12.
Victims.
Aggravated assault with deadly weapon as to Mr. Jackson Buckingham's, known in the record as Jackson Heil. The indictment states that Mr. Robinson pointed a gun towards Mr. Jackson Buckingham. That did not occur. We're seeking directed verdict. There's no testimony in the record that Mr. Robinson was involved in an aggravated assault as it pertains to Mr. Jackson Buckingham. Count 13, aggravated assault with deadly weapon, Mr. Vikyat Gatani. We submit to the court that there's no evidence in the record and there's no conflict in any of the evidence that would support that my client, Mr. Robinson, pointed a gun towards the direction of Mr. Vikyat Gatani. Therefore, we're seeking directed verdict on that count. On counts 14, aggravated assault with a deadly weapon as it pertains to Christian Riggs. We submit to the court that there's no evidence in the record to support that our client, Mr. Robinson, pointed a gun towards the direction of Mr. Christian Riggs.
Does she think if she just says it,
as
that
it
it becomes
pertains
true?
to
Stephanie, we've got the live feed lined up for the Kelly trial. It has not gone live yet. As soon as it does, we're going to interrupt this, take the Kelly update, and we'll be back.
That our client, Mr. Robinson, pointed a gun towards or in the direction of Mr. Hooper on November 8th, 2019, as charged in the indictment. As to counts 16, aggravated battery, as it pertains to Vikyat Gatani, we submit to the court that there is no evidence to support that our client, Mr. Robinson, fractured the skull, causing permanent scarring on the head of Mr. Gatani. No testimony from Riley or Kalish as to any of these counts, 1 through 16. Aggravated battery, Christian Riggs, count 17. We submit that there was seriously disfiguring of.
I'm going to save you on 17. I'm going to be granting a directed verdict on 17 because Mr. Riggs said my nose might have bled slightly into the story. And this is one of the models. He will let us know if his nose had been disfigured. So the state has failed to prove an essential element, which is serious disfigurement. Has nothing to do with who did it. So we're clear. It didn't happen. So 17, I will be directing a verdict on.
Thank you, Your Honor. As to counts 18, we have participation in criminal street gang activity. We submit that the law, let me go into the law. 1615.3.3 states that a criminal street gang means any organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal gang activity as defined in paragraph 1 of the code section. The state charged OCGA 1615.4a, it shall be unlawful for any person employed by or associated with a criminal street gang to conduct or participate in criminal gang activity through the commission of any offense enumerated in paragraph 1. So when we're talking about to establish the violation of a Street Gang Terrorism or Prevention Act, the state must show count 1, element 1, the existence of a criminal street gang as defined by statute. They must also show that the defendant's association with the gang. They must show that the defendant committed any of several enumerated criminal offenses, including those involving violence, possession of a weapon, or use of a weapon, and 4, that the crime was intended to further the interest of the gang. There has been not even a scintilla of evidence, 1, that Mr. Robinson was furthering the intent or the interest of any gang. As it pertains to
all the stuff taken back to the gang place and dumped on the bed,
street gang,
counted.
Based on this witness that we had this morning,
Sold.
He is claiming that our client is a member of the YSL gang based on several different clips of the exact same guns up video
But isn't that a question about the sufficiency of the evidence? I mean, I don't know who has ever taken the stand to say Mr. Robinson is not a member of YSL. There are people who have said that. It may not be particularly compelling. It may be far from reasonable doubt, but remember the test you enunciated at the beginning. If there is no conflict in the evidence and there's no evidence supporting X, but there is evidence. There's an expert testifying based on these different things. I feel like he's a member. That may not be compelling to you. More importantly, it may not be compelling to the jurors, but that's different from what you've been able to say about the crimes that occurred inside the house, where you accurately say, no one can say they saw my client inside the house. The jurors have seen your client with the bandana, with guns associated with other supposed members, holding up supposed signs. It may be that the expert's not deemed to be very credible, but this is in some ways the opposite of the good argument you were making with all those other counts, where the state's not going to be able to say, oh, wait, Judge, you forgot about witness X, who said, no, I saw Mr. Robinson in Wiley Street, or his phone was there. None of that happened. But we got to see even more pictures of your client doing alleged gang signs, flashing this and that on sort of the redirect of the investigator, because you pressed him. That's really not a lot of pictures you're talking about. So I just said a lot. But again, if the test is no evidence and there are no conflicts in the evidence, it's sort of the reverse. The only evidence in the case so far is an opinion of an expert that your client is associated or is a member of the gang.
And as it pertains to the fourth element of that, Your Honor, the state has to prove all the elements. They're not allowed to prove the first three.
Right.
So now we're at the
nexus,
the intent to further the interest of the gang. And we don't have that here. In fact, the evidence before the court is that the whole robbery, according to the testimony of Kalish, was a design by Riley. And that Riley said, hey, let's go rob these people. And according to the evidence, the state is not alleging that they're members of the YSL gang. So we would submit that the state has failed to meet at least element number 4 as it pertains to count 18 of the indictment. Possession of a firearm during the commission of a felony, count 19. According to the state's indictment, it states that my client engaged in assaulting with assault-style pistol, a firearm during the commission. Your Honor, we've had so many descriptions of a weapon in this case that the state has failed to even meet the burden of saying what type of weapon was used in this case. And as it pertains to the alleged victim in that count, it's Mr. Riggs that our client is supposed to be alleged to have committed the crime against. Based on the fact that the state cannot, one, identify the particular weapon, and there was several times that the state attempted to try to have one of the alleged witnesses testify, or alleged victims testify that they could recognize a weapon, but now we have weapons all over the place. So we submit to the court that the state has failed to meet its burden as it pertains to our client on count 19, and directed verdict is warranted pursuant to the law. As it pertains, Your Honor, to count 20, we didn't go into that because count 20, although in the exact same indictment with our client's name on it, is not applicable to our client, but I just wanted the record to be clear as to why I'm not addressing count 20.
Welcome, Broken Bakers.
Doesn't apply to our client. So if the court wants to grant a directed verdict on something that's not applicable to our client, we move for it.
You're not going to oppose it?
I won't oppose it.
Okay. Thank you. All right. Mr. Pritchett, you got to hear actually a very thorough and accurate description of what a motion for directed verdict is and the standard that I have to apply in the introductory comments that Ms. Mignot made. So I'm not going to need to explain to you what it is. You're free to make one as well if you want to argue for a directed verdict as to one or more of the counts that names you. You don't have to, but if you want to, now's the time. But I'd ask you to come to the podium so that Ms. Rivers can hear you through the microphone, please.
Okay. Welcome, everyone who came over from Broken Baker. Good to have you here. We're about to interrupt this proceeding, which is riveting. to jump to the George Kelly trial, where the state is going to make the decision whether or not they're going to retry George Kelly. They had a hung jury, a little over a week ago, and they're deciding today. We'll have to tell the judge if they're going to prosecute again or if they'll drop charges.
Yes, I would like to move this court for a directed verdict of acquittal on...
Nothing like a pro se doing a directed verdict
1 through
argument.
20, excluding 17, which you already said would be ruled upon. I guess to go into detail, count 1, home invasion in the first degree. The state has not proven beyond a reasonable doubt.
So I'm trying not to interrupt you. I did a bad job of staying out of Ms. Mignot's way while she was arguing. I apologize to her. But the standard right now is not proved beyond a reasonable doubt. It's actually an exceedingly low standard for the case. My finding isn't you've proven your case. My finding is you haven't done so poorly that it would be unfair to let the case go to the jury. That's how you win, would be by convincing me that it would be a miscarriage of justice to let the jury even deliberate on this, because it's so clear from the evidence that the state has failed. So it's a low burden for the state, a high burden from you, because it's an unorthodox request. It's to say, don't let the jury decide this. The whole point of giving you and Mr. Robinson a jury trial is to let the jury decide and not me. But sometimes I got to step in. So back to count 1.
Yes, and it is believed by me that it would be a failure of this court to allow the jury to deliberate on this count, because more than one element of this crime has not been sufficiently proven by the state.
I'm so glad he changed from being a soft sit to just pro se.
That
I'm gonna interrupt you again, just because I'm gonna let you flesh out all these counts. But let me tell you what I find. I find that the state has proven every single element of the home invasion, where the challenge is who did it. I think that there is uncontroverted evidence that 2 people entered the residence of another person without authority, clearly with the intent to commit a felony because they beat some people up and took stuff. And that residence was occupied by people who were authorized to be there. They weren't squatters. The state's proven all that. Every victim in this case has said that's what went down. The big question is, well, who did it? And so we talk about alleged victims. These are all victims. They may not be your victims. They may not be Mr. Robinson's. But I'm going to let you know right now, you're not going to convince me that the question of was there a home invasion shouldn't go to the jury, unless you can convince me right now that there is no evidence that connects you to that home invasion, because that's really what you're going to be arguing as to all the armed robberies and the aggravated assaults, because every victim said these guys had guns and they pointed it at us. There's your ag assaults. Every victim said I had stuff taken from me at gunpoint, and that's all listed there. So all those things happened. I believe they've been proven. Where there's going to be some fighting in front of the jury during closing arguments is, did the state come close to proving, did they meet their burden, that it was Robinson and Pritchett? So focus on the lack of evidence that you were one of those 2 people. Does that make sense?
Yes. Because
if you focus on, well, I don't know that they didn't have authority, that we're not getting anywhere.
Okay.
Judge says use the Shaggy defense.
Well, to continue, yes. It is believed that the count of home invasion has not been sufficiently supplied or backed by any evidence to which I committed such act. The evidence has not proven or in any way stated that I committed the act, down from the testimonies of the victims and the testimonies of the co-defendants. There was no consistent or any basis to say that I was the one that committed this home invasion. We can even,
Did he call himself the accused?
the narrative from Officer Wright.
I missed that. If he said it, I need to count it.
That briefly describes the two assailants that committed that home invasion. One being slim built and of light complexion, and the other being heavy built of dark complexion. I fit neither one of those descriptions. Okay, and again, I would ask this court to direct verdict on that account of.
We are back. We're back in the Kelly Court live hearing update right now. We're waiting for this should be quick.
No. The record in the Santa Cruz County criminal law and motion calendar for Division 1 for Monday, April 29th, 2024. If you are the victim of a crime with a case pending before this court, you are advised that you have the right under Arizona law to justice and due process. This includes the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at the court proceedings, to a prompt and final conclusion of the case, to choose whether or not to be interviewed by the defendant, the defendant's attorney, to be heard before the court makes a decision on release, negotiation with police, scheduling, and sentencing, and receive restitution from a person who has been convicted of causing your loss. If you have not already been provided with a full statement of all victims' rights, please contact the Victim Services Division of the Santa Cruz County Attorney's Office.
Si usted es la víctima o representante de víctimas con un asunto pendiente ante este tribunal, se le informa que tiene derechos bajo la ley de Arizona que incluyen, entre otros, el derecho de ser tratado con justicia, respeto y dignidad, a un juicio sin demora, de estar presente durante los procesos judiciales, de elegir si se someterá a una entrevista por el acusado o su abogado, de ser escuchado antes de que el juez decida sobre las condiciones de libertad, la negociación de un convenio, la programación de las citas y la imposición de la pena, y de recibir restitución por parte de la persona condenada por haber causado sufrimiento. Si aún no se le ha proporcionado una declaración escrita de todos los derechos que tiene.
You're kidding me. Hang on. Let's wait. They knocked the cable loose. Give them a minute. We have no feed. It just might come on with the bars and tone here, and I want to save your ears if I can.
Good afternoon, Brenna Larkin on behalf of George Allen Kelly. He's present out of custody. I believe on Zoom is co-counsel Ms. Lothorpe.
She is. I can see her on the Zoom call.
Welcome,
Ms.
Lothorpe.
This case was tried to a jury. The jury was not able to reach a verdict. The court declared a mistrial. I think it was on Friday, April 19th, 2024. We set a hearing for today's date to status hearing to determine what the plan is as far as the state's concerned. So Ms. Hundley's on her feet, and Ms. Hundley, what can you tell the court?
Your Honor, because of the unique circumstances and challenges surrounding this case, the Santa Cruz County Attorney's Office has decided not to seek a retrial.
Yes.
All right. Is that a motion to dismiss?
We can file one, Your Honor.
They're going to dismiss the charges.
We don't have any objection to that, Your Honor.
All right. That's fine. So the state can file a motion to dismiss, but there's an issue about whether I assume the state's going to ask for a dismissal without prejudice. Is that right?
Yes, Your Honor.
All right. Do you want to be heard on that? Or do you want us to set a hearing on whether or not the court should dismiss with or without prejudice at a later date?
We can set a hearing at a later date, Your Honor. That works for us, Your Honor.
All right, very well. So the state will file a written motion to dismiss. Then the court will set a hearing. The hearing will be regarding whether or not the court should dismiss with or without prejudice.
Okay, so there's one more hearing. That's an important one.
Ms. Lothorpe?
Yes, sir.
Anything
So
from,
am I on mute?
No, I can hear you. Anything else from you?
I'm not on.
Anything else from you?
No, sir. It was a pleasure, Your Honor.
All right, very well. Then we're adjourned on that matter. Thank you. But I will, hold on a second. Mr. Kelly and Ms. Larkin, the court is going to grant the motion to dismiss, obviously. The only issue remaining is whether or not the dismissal is with or without prejudice.
Which means
the state having indicated that it's filing a motion to dismiss, the court's going to grant the dismissal. It's also going to exonerate any bond that's been posted. The defendant is free from any restrictions or encumbrances associated with this case.
Thank you, Your Honor. We'd also ask for the return of his property.
Any objection?
No, Judge.
Any property that Mr. and Mrs. Kelly that was
refile.
seized and taken into custody by the Santa Cruz County Attorney's Office or the Santa Cruz County Sheriff's Office is ordered to be returned forthwith to the defendant.
You know why?
Judge. And when the state files their motion, we'll ask that the dismissal be with prejudice.
We'll have a hearing on it.
Yes.
And they're going to
All
get
right.
it.
Thanks, but we're adjourned that time.
All right. Okay, so the return of the property, when the state does not object to the return of the property,
Yes, CR 2023-27.
that's the evidence.
Can't shoot back.
They're giving back the evidence.
I need to go get the
Okay.
Yes.
That's the end of that.
So let's let this.
Good afternoon, Your Honor. Matthew Cannon.
Okay, now they've got another case that they're bringing. They're giving back the evidence, which means they're not going to refile these charges, because then they would have to recollect the evidence, and now you have chain of custody issues. You have all sorts of problems. There will be no additional charges. I realize there's another case, or there's another hearing, right? They're going to have a hearing, and I'll show you this for just a minute. Well, let's go back here, because that'll confuse people. There is going to be one more hearing where the judge decides whether or not to dismiss with prejudice or without prejudice. All that means is, can they refile? Can the state refile the charges? If it's dismissed with prejudice, that's the judge saying, this is done. This is final. You had your shot. You don't get another. But if it's dismissed without prejudice, it means, well, this time it's done. But you can file again, and we can do it again later at some other time, at your convenience down the road, at any time within the statute of limitations for the crime at hand. So the decision about prejudice or not prejudice is going to be coming later. It's going to be a very quick decision. The defense has already said, they said, we're going to be fighting for prejudice. But the state said, hey, because of the unique circumstances in this case, we're not going to refile. Yeah, the unique circumstances are, nobody believes us. That's a unique circumstance. I guess they've never been in that situation before. We convinced one juror. But so Mr. and Mrs. Kelly are free. Bond is returned. There are no restrictions on their travel. There are no restrictions on firearms. There are no restrictions on anything that was put in place as part of that bond. That's now gone. In addition, all his property, including the firearm, the AK-47, his pistol, I think that was also taken, Mrs. Kelly's phone that was seized, anything that belonged to them, even the clothing he was wearing, all of that is going to be returned. So he gets his bond money back. I'm not sure how much he put up, if it was a cash bond or if it was through a bondsman, but everything is back. And basically it's done, and it has every indication of never coming back up and being a problem again for them. So, yeah, the poor investigation was a unique challenge as well. I don't think they can sue Francisca. Maybe Matthew Harris could fill us in on this, but to my knowledge, when the state tries to prosecute you for something and they lose, you can't turn around and sue them unless there's something really egregious. I think they're protected from that. There is an active situation. U.S. Marshal shot and killed North Carolina. It's in Charlotte right now. I think 7 officers were shot by what I saw. I'm sort of trying to monitor that. But let's jump back over to our... Oops, let's go right here. Let's jump back over to our trial in progress. But good news for the Kellys that they're not going to refile those charges. They get their money back from Vegas, right? All right, give me a second here. Let's get everything reconfigured. Let's do this.
Acquittal on count 1.
Okay,
on count 2.
The pro se defendant is now
if
making
you're comfortable doing it, I'd ask you to lump all the armed robberies together, because I'm guessing you're going to have the same. If you've got something unique to count 6, let's talk about it. But if it's the same argument as to counts 2 through 8, those are all the armed robberies. Share with me why you think I should direct a verdict as to all of them, because I think they move as a block. Mm-hmm. Either they're all going to the jury or none of them is.
To lump them all together, yes, I do find that the court should direct verdict of acquittal on counts 2 through 16, 2 through what it was.
So 2 through 15 is the armed robberies and the ag assaults.
You said 2 through 8, correct?
Those are the armed robberies.
2 through 8, which are the armed robberies. And I find that this acquittal should be established by this court because there is a complete lack of evidence that connects and shows that I was one of the individuals that committed this armed robbery.
Wonder if the judge is going to grant any of these.
Prove that, according to count 2, that I was the one that had an intent to commit theft or take the wallet and property of Holden Carmody. According to count 3, there is no evidence to prove that.
For each of the counts, you're saying there's a lack of evidence showing you had the intent to take that which was allegedly taken. Okay.
That proves lack of intent or that I was the one that actually, robbed the stolen items.
Okay.
And again, to support that acquittal, it goes back to just the description of the alleged assailants. Neither one do I fit. On count 9, which is aggravated assault with a deadly weapon.
And let's do the same with the aggravated assault. So 9 through 15 are sort of carbon copy counts, just replace the name of the victim.
So I would ask that the court, do move in good faith a directed verdict of acquittal on counts 9 through 15, being that there is no evidence to support that I unlawfully committed an assault on any of the victims in each count. There is no evidence to prove that I holstered a firearm that day or that night or at any point in time. And moving on to count 16.
There are 20 counts, so he's almost done.
Which is...
The judge has already said he's going to grant one of these.
Aggravated battery. I would, in good faith, ask the court to move on a directed verdict of acquittal on count 16 because there is a complete lack of evidence proving that on the 8th day of November that I was at 1040 Wiley Street where this incident occurred and that I did maliciously cause bodily harm to Gatani by fracturing his skull. There is no evidence that I committed such act. Skip 17.
Yeah, as soon as the accused 18, decided to take a seat in trial, that was a reversal.
In good faith for a directed verdict of acquittal on the count 18, which is participation in criminal street gang activity.
Arizona is not retrying Kelly. They're dismissing charges.
The testimony from the expert witness, the supposed expert witness by this court.
Supposed expert. The court deemed him an expert. Don't impugn the reputation of the court.
Indicate
your motion
that I was part of a gang. He showed 3 pictures of me, while at the same time admitting that he has never seen me throw up this alleged gang sign. And he also admitted that he has never seen me use even the verbiage of this gang, which I believe is a complete contradiction from someone who was supposed to be a gang member. he testified that everybody he has assessed to be in that supposed gang of YSL, he can at least bring forth one piece of evidence to show that they have at one instance threw up that gang sign or at one instance even used the verbiage of that gang sign. And I do not fit that criteria in neither of those categories based off his admission and what his assessment was of me. I believe it is insufficient to say that I participated in any street game activity because it has been insufficiently proven. It has been sufficiently proven that I am not in a gang.
It's been proven that he's not in a gang? By who?
Count 19. I would like to, in good faith, move this court for a directed verdict of acquittal on the count of charge of possession of firearm during commission of a felony. There has been no evidence to show and prove that I holstered any type of firearm, nor has there been any evidence to prove that any type of firearm was ever within my reach.
He holstered one?
Which are elements of this crime, which again have not been sufficiently proven and backed by any type of evidence.
Other than the pictures of the firearms within your reach, I would say those might be evidence of that. Or suspected firearms.
Again, I will move to count 20 and move this court to a directed verdict of acquittal on this count, which is possession of firearm by first offender probationer, which again, there has been no evidence to prove that I holstered on the 8th day of November or any time a firearm, assault style pistol, or any type of firearm during that day or any day, nor was there any type of firearm within my reach or around me. There has been no evidence to prove such. And so again, I would in good faith move this court for a directed verdict of acquittal on counts 1 through 20.
There you go.
Thank you, sir. Mr. Hiles, I've got a few questions for you, and then if there's anything you want to add, you can do that. What is your response to Ms. Mignot's observation that in counts 6 and 12, the name of the alleged victim is incomplete and thus incorrect?
So I don't think there's any requirement that I put the individual's full name first, last, and middle. When I had the...
well, you couldn't just put Fred, because correct. Then someone could be prosecuted 10 times for different Freds, the same Fred.
I agree with that. But when Jackson took the stand, I asked him all 4 of his names. Then he explained that because there is the 4th name, Heil, which is his technical last name, it is on a different line. And so when you had the 3 names on the first line, it appeared on his ID. It appears on his ID that his last name is Buckingham. And I think the fact that there's no confusion that he is Jackson Buckingham, and he acknowledged that.
Okay. Count 16 is the first of the aggravated battery counts. Aggravated battery can be committed when first there's always the element of maliciously causing bodily harm to another person. That's alleged in the count. But then there is serious disfigurement or loss of a limb or at least temporary loss of use of things. What is 16 alleging?
Let's withdraw this.
So it is malicious, did maliciously cause bodily harm to...
Element 1.
Yep.
Element 2 is you got to pick one. Which one is picked here?
So it would be serious disfigurement. The Mr. Gattani did talk about the scar.
I understand the evidence. I want to make sure that it was adequately charged. So if you look at count 17, what does count 17 say? What was the species of aggravated battery?
So it does say seriously disfiguring, but the difference is that he was alleging a broken nose. That's something that couldn't be seen. And I get, look, after speaking with Mr. Riggs prior to his testimony.
You don't need to worry about 17 because it's out. I'm just contrasting. You're claiming that 16 is a serious disfigurement allegation.
It is.
And clearly the author of the indictment knew how to include the word seriously disfiguring. They're not in count 16. And so I'm wondering if you think it is adequately pled.
I do think it is adequately pled because it does say permanent scarring. And so that's, yes, I do think it's adequately pled.
Okay. Counts 19 and 20. No firearm recovered. Not unique in the annals of criminal history. I've been looking for case law, and I'm going to ask you to get your appellate team to find some. Other than witnesses saying they were big, scary looking guns, how do we know that they were actually firearms? If you possess a pellet gun, for example, that would be insufficient for a conviction for count 20. If it turned out that Mr. Pritchett was there and they caught him and they seized the gun, it was a pellet gun, that's not good enough for 20. We don't have a gun at all. And so I'm going to ask you to find, I'm going to reserve ruling on 19 and 20, just because I'd like to have some case law that says the description of the victim can be enough. Most of the cases I bumped into were murder cases, and the way you know it was a real gun is that a bullet came out of it. Right. Your last trial, there was no issue with that. Someone got shot. No one got shot here. They got whacked with the gun. So it could be a replica metal gun that would cause bleeding and fracturing of the skull. So we don't need to resolve it now, but I'd ask for some case law that 19 and 20 ought to go to the jury, even though no one has testified that it was a real gun. Okay. Those are the only questions I have. You're welcome to add more if you want, but those are the areas of concern that I have.
No, I see your concerns, and I guess I will just for the record right now, I think, and I'll get this case law, I'll talk to the appeals department, but the circumstances surrounding the events, it would be foolish. And you can look at the circumstances surrounding the events to go into a house not knowing whether someone else was armed or to hold yourself whether you are armed. To do so, to hold yourself out, to have a firearm and not be able to actually react with it.
Right, you lose that gunfight.
You lose the gunfight. And so I will note the court's concerns or
question.
The
court's question.
But that is the counter to it. And I think it does survive enough to get to a jury.
Well, it survives enough to make it through right now.
Yeah, that's what I'm, yes. Okay.
Yeah. I reserve the right to pull it at any point if there's not case. There's got to be case law to that effect. I couldn't find it because I was much more focused on what Mr. Pritchett had to say. It just dawned on me, and this has to have come up before. But all the cases I ran into where gun not recovered, it was a murder, and there wasn't but we know it was a gun because the person got shot 3 times.
We already covered.
We don't have that here.
Just rewind.
Okay,
we covered it live.
You're not pushing back on count 17. No, I had a conversation with Mr. Riggs coming in, and he said, "Oh, by the way, after thinking about it all this years, I don't know if the bridge in my nose was caused by a soccer injury or me getting hit in the nose." And I just said, "I'm not going to ask you any questions about it anymore." Okay. I'm conceding. I don't. No. All right. It's not there.
Thank you. So,
Your Honor, we just have one case to cite for the court for the record.
Great.
Mahone, Mahoneb State. It is 348 Georgia Act 491. And it is a home invasion count. States that in the case, however, the uncontroverted evidence showed that Mahone did not possess the iron he used in his assault of Willis at the time he entered the apartment. Instead, he found the iron after he made his unlawful entry, and accordingly, the state failed to prove an essential element of the crime of home invasion in the first degree.
Got it. Thank you.
Could you, I hadn't sat down. Could you just give me that site one more time, please?
348 Georgia App 491. It's a 2019 case. Mahone v. State, Mahone v. State.
So here's where we are. I need to rule. Yes, sir.
Before you rule, can I please add something quick for the record?
Sure.
Regarding the direct verdict petition. It's just getting my encouragement. It has been brought up in previous hearings. I would just like to state that this indictment purports to be invalid, being that it was not returned in open court, and that the clerk has attested to it. I have evidence that the clerk said that there are no minutes that it was purported to be returned in open court, and I believe it was on the hearing of June 27, 2023. The state also attested that no minutes exist of the indictment being returned in open court, and according to case law, for an indictment to be valid presentment, it must be returned in open court, and it must be affirmatively shown by a record entry in the minutes.
Okay.
And there needs to be a file endorsement on the indictment itself to show that it was presented by the grand jury and filed in open court. This says filed in office.
Got it. Thank you. You've preserved that argument.
He's already ruled on it.
In James versus State at 316 Georgia Appeals 406, the Court of Appeals framed the standard for motion for a directed verdict of acquittal as follows: that it should be granted only when there is no conflict in the evidence, with all reasonable deductions and inferences therefrom demands a verdict of acquittal as a matter of law. I don't find that that is the case for counts 1 through 16, or at this point, 18 through 20 either. I appreciate the record that's been made so far by defense counsel and by Mr. Pritchett, which is that there is no direct evidence that places Robinson or Pritchett inside the Wiley Street address. This is a classic circumstantial case for that one piece. I think there is more than enough evidence for the question to get to the jury, that there is direct evidence that Pritchett and Robinson were in Riley's Mercedes and got to within a stone's throw of Wiley. Riley and Kalish get out. When Riley gets back in, Pritchett and Robinson aren't in the car anymore. We learned from both the ladies later on, they had masks, meaning the guys did. They were dressed in dark clothing. Lo and behold, the people who make entry into the house are described for the most part as wearing dark clothing, definitely wearing masks. And then as Riley's trying to figure out what to do next, who hops back in the car but Robinson and Pritchett, and then Kalish gets in the car. They all go back to the Voss Coleman address, and we know what the testimony is. The state's case rises and falls on the credibility of Kalish and Riley, with some circumstantial corroboration, like who was wearing the jacket going in, who was wearing it going out, things being thrown out of the car, etc. But that's just a circumstantial case. The fact that a piece of it is circumstantial doesn't mean that a directed verdict is appropriate. Ms. Mignot is right. Every time she said it many times, that there is no evidence that there's no direct evidence, an eyewitness who said, no, the guy with the monkey mask or the guy with the purge mask was Mr. Robinson. And there's conflicting evidence. These people who were drunk or high or both and under stress because they had guns pointed at them and there were people bleeding out of their heads in front of them, have different recollections of what people looked like. And that is, to me, utterly unremarkable in situations like these. And it is certainly fodder for closing argument. It is fodder for reasonable doubt, but that's not the test I apply. If I construe the evidence in the light most favorable for the state, the jurors could reasonably credit, despite their warts and bumps and whatnot, Kalish and Riley's testimony that this was a 4-person operation. And the other two aren't mystery people. They are Robinson and they are Pritchett. And there are some social media communications afterward that are problematic for Mr. Robinson, not so much for Mr. Pritchett. And I think that gets us to the jury on the home invasion, the armed robbery, the aggravated assaults, and the 2 firearm counts, assuming no gun being recovered is sufficient. I'll tell you, the gang, this is a home invasion case with a gang charge strapped onto it. And I regret not having bifurcated it before the trial started. But there is some evidence that this is gang related. It was not concocted by a gang member. At best, it was a gang hanger-oner, meaning Ms. Riley.
That's an important issue.
But it was something that then Voss Coleman and Mr. Pritchett, and then ultimately Mr. Robinson latched onto.
Rewind.
There is some evidence that doing something like this furthers the interests of the organization, that being YSL. And again, my assessment that it's not a bright and shiny gang charge doesn't mean it doesn't go to the jury, given the standard that I must apply for motions for directed verdict. The count that fails is count 17. It alleges that Christian Riggs's nose was seriously disfigured. Christian Riggs testified to the contrary. The only evidence of the nature, scope, and extent of Mr. Riggs's nose injury is that I was grappling with someone, I got hit in the nose, not even by the gun, and it may have bled, either said a teeny bit or a tiny bit, and that's not serious disfigurement, and it's not a broken nose. But the state concedes that. So count 17 at this point, it's out. It will not go to the jury. I'm reserving judgment on 19 and 20, and you can renew these motions if there's more evidence presented. I can always reevaluate. Ms. Mignot, anything you want to get in the record in connection with my ruling on your motions for directed verdict?
Matthew, I've got a question when we get a minute.
I just wanted to get clarity from the court.
If you're available.
If we are providing the court with case law, is that going to be tomorrow regarding counts 19 and 20? Is the court going to reconsider its ruling regarding directed verdict?
Sure. So 19 and 20 right now are going to the jury, but I am open at any point. I can take it away during their deliberations. I mean, I can sua sponte direct a verdict whenever. And if I'm legally required to do so, not because of the evidence piece, I think there's plenty of evidence for jurors to decide if they conclude that Mr. Robinson and Mr. Pritchett were the home invaders, they had what appeared to be firearms in their hands. So that's been established, but is appearing to be a firearm enough? That's the piece. And so I want to make sure we're operating in a safe space. I mean, worst case scenario, it would be cleared up at a motion for a new trial if your clients are convicted, because then everyone would have plenty of time and people with super sharp appellate brains would have time to say, you know what, Judge, you let that go to the jury. But you said during the course of the directed verdict discussion that there's no evidence in the record where someone said, oh yeah, that was a Draco. I touched it. I pulled the magazine out. There were bullets in it. It appeared to be a big, scary weapon, or to your point, sometimes it was a small, scary weapon because different witnesses saw the guns differently. I just want to make sure we aren't sending something to the jury that they shouldn't be deciding because if there isn't sufficient evidence that it's a real gun. I don't know what that would be, that sufficient evidence. And so it's a request to everyone, send me cases, and there's no deadline. If you send your case day after tomorrow and the jury's still deliberating, I can always say, stop worrying about counts 19 and 20.
Thank you, Judge.
Okay. All right. Mr. Howes, you had jumped up at some point. Was there something you wanted to add? Because if it's case law, don't just send it via email to everyone later. Okay. All right. We are going to bring the jurors back out before I release them for the day. Ms. Mignot, well, let me do this. Mr. Robinson, it is time for us to have that discussion that I have forecast. Do you understand, Mr. Robinson, that you have a right to testify? And that if you wish to testify, no one can prevent you from doing so. Ms. Mignot can't tackle you and say, don't take the stand. It's going to be a decision for you to make. Do you understand that? Do you understand that in the same way, no one can force you to testify? If you don't want to testify, even though Ms. Mignot or Ms. Blake may be saying, this is your key to freedom, no one can make you testify. And certainly the state can never call you as a witness in this case. Do you understand that? Do you understand that in a moment, I'm going to ask you and not Ms. Mignot whether you want to testify?
Yes, Your Honor.
Do you understand that if you choose not to testify, I will tell the jury that they should draw no conclusions or inferences or anything at all hurtful to you in any way about your decision to exercise your constitutional right to remain silent? Do you understand that if you choose to testify, not only do you answer the questions from Ms. Mignot, which may be difficult because it's a difficult case, but they're friendly questions, but you'll also have to answer any legally proper question from Mr. Hiles or Mr. Pritchett. And those may be ones that are awkward for you and you don't want to have to answer, but you will have to answer them. Do you understand that?
Yes,
in other words, you'll be subject to cross-examination. All right, Mr. Robinson, do you wish to testify in your trial?
Not wish to testify now.
I find that Mr. Robinson has made his decision not to testify with a complete understanding of his rights, and I will instruct the jury that they should draw no conclusion, inference, or any other finding from the fact that because you have no burden of proof at all, you chose not to testify. Okay. Ms. Mignot, will you be presenting any other evidence at this juncture on behalf of Mr. Robinson?
No, Your Honor.
All right. Mr. Pritchett.
It's just
Do you understand that you have a right to testify and that if you wish to testify, no one can prevent you from doing so? Do you understand that if you don't want to testify, no one can compel or force you to testify? Do you understand that if you do not testify, I will instruct the jury that they should draw no conclusion or finding hurtful or harmful against you? Do you understand that if you choose to testify, you don't get to just tell your story your way, but you will be subject to cross-examination by both Ms. Mignot and Mr. Hiles? You don't get to take the fifth on cross-examination. You understand that? Okay. Do you wish to testify, Mr. Pritchett?
This decision has been made right now.
I just asked the question.
At this moment, I don't.
Okay. So what's going to happen next is I'm going to bring the jury in. I'm going to ask, are you going to be calling other witnesses?
Yes, I'm in the car with.
So that maybe doesn't work.
Run into any problems, I know I don't have any more like time than tomorrow.
Right. Well, you lucked out. It would be tomorrow. We wouldn't call those witnesses. But here's what we're going to do. The jury's going to come back in. I'm going to ask Ms. Mignot if she is going to be presenting any evidence. She's going to say, nope, Mr. Robinson rests. I'll repeat to the jury, okay, he has no burden of proof, no obligation to present anything. Then I'm going to turn to you to ask you if you're going to present any evidence. And your answer is going to be?
Yes.
Okay. Tell me not the content of that evidence, but the vehicles through which you will present it. Who do you intend to call as a witness?
I believe the name was Marquise Abdullah.
Okay, that was one of the names that you provided. And Marquise Abdullah is who to you?
Somebody I know.
Someone you know. Okay, well, you know me too.
He's a friend in my gang.
Did you end up getting any contact information for Marquise Abdullah so that Ms. Mignot and Mr. Hiles can talk with him?
Yes, I did.
Date of birth, address.
Number, contact information, and address.
Okay. Anyone else besides Marquise Abdullah?
Yes, but I didn't get their full information, so I'm going to say no.
Okay. So your plan, assuming he shows up, and I know it's a little complicated for you to get people to show up, would be tomorrow morning at 9 a.m., you'd have Mr. Abdullah testify.
Yes.
Okay. And because no one really got notice of this person other than on Friday you mentioned his name, can you give us a thumbnail sketch of what he would be talking about?
But it's, where he was on November 8th.
It can't be alibi.
What he recalls me doing or, participating in on November 8th.
So remember, I've already told you that you're not going to be able to use any
alibi witnesses. So you're not saying that word, but if you expect Mr. Abdullah to say anything along the lines of, Mr. Pritchett, whatever he's going to call you, was with me all day and all night on November 7th and November 8th, he may not testify to that.
Okay, I mean, it'll be, it's not gonna be on those lines, but it'll be referring to mainly who was at young man's apartment.
Okay. Okay, but you do not intend to rely on Mr. Abdullah's testimony to give you an alibi, that you could not have been involved in this home invasion because you were with Mr. Abdullah. Understand what I'm saying? Because that's what alibi is. So if let's say this, Mr. Abdullah said, hey, I was at Young Bands as well, and Mr. Pritchett was there, and I'll tell you, Tyrone Robinson and some guy I don't know, they left with the two ladies, but Max, he stayed with me at Young Band's apartment all night long. And then Tyrone came back with this other strange guy and these two girls, and they had all this stuff they had stolen. That's alibi, and that's not permissible at this point.
I do comprehend it.
Okay.
So it'll be, I mean, however it is, I mean, I don't see him saying yes. I don't see him saying in the way you structured it, I don't see him saying.
Okay. All right. What is Marquise Abdullah's identifying information?
I'm struggling to find right now, but it's here.
All right, well, that's all right. Let's not find it right now. We'll find it after we release the jury. So what you are committing on the record to me is that at most tomorrow morning, you're calling Mr. Abdullah, and then you may change your mind and choose to testify, which you're allowed to do, but no other witnesses.
Lauren Riley calls.
So we should have Ms. Riley back tomorrow.
Yes.
Okay. I assume we can do that, but we'll work on it. Okay. Anything else? Because tomorrow is not the time for surprises. Abdullah, Riley, Pritchett at most.
Should I just name the possible though?
Anyone that you might call tomorrow, you need to let me know, so that it's really not letting me know, it's letting Ms. Mignot and Mr. Hiles know.
Okay, well, to Officer Wright, please.
Okay.
Buckingham.
So this is the list you gave before. We'll talk about it after the jurors leave, and then you can let me know why you think those folks might show up. All right. Mr. Hiles, anything else before we bring the jurors in?
Are we going to finish up all the stuff relating to witness information after the jurors?
Yes, sir.
Nothing outside of that.
Okay. Ms. Mignot, anything else before we bring the jurors in?
Nothing further.
Okay. All right. Let's bring the jurors in, please.
All right, so the time for Mr. Pritchett to have filed a motion saying we are going to be presenting an alibi defense is past. That is something that happens early on in the trial, even pre-trial. It might be the right time. And because it wasn't raised before, the judge has ruled it's inappropriate now. So he can't call a witness to say, oh, I don't know anything about that crime, but he was with me all that night. That's not going to fly. If that does go down that way, the judge will shut it down tomorrow. Mr. Robinson and his team is not presenting any defense, so it will just be Mr. Pritchett tomorrow. We'll definitely be in verdict watch tomorrow as well. Possibly 3 witnesses if the police officer testifies. Lauren, I think he said Laura. I forgot what her name was. Riley, one of the girls, and then his friend Abdullah.
Thank you, Deputy Gordon. Ladies and gentlemen, welcome back. We did what I told you we would do, which was work through a whole bunch of things that occur after the state rests. And we are not going to keep you here much longer, but we're ready to proceed with a little bit more of the case. And my next step is to ask Ms. Mignot if you intend to present any evidence on behalf of Mr. Robinson.
Your Honor, defense rests on behalf of Mr. Robinson.
Thank you. And ladies and gentlemen, as I forecast for you, as a possibility, because criminal defendants don't have any burden of proof, it is not at all uncommon for a defense attorney to say, we're not presenting anything in our case in chief. I did what I did with the state's witnesses, and we're not going to be calling any witnesses. That's what Ms. Mignot has just said. And so she's rested, which leaves the accused. Sir, will you be presenting any evidence on your behalf?
Yes.
Okay. That's where we're pausing. I've had a discussion with Mr. Pritchett, the accused, about his presentation. We will start that first thing tomorrow morning. We will get to closing arguments tomorrow. We will get to the jury charge tomorrow, and then you'll begin your deliberations tomorrow. The fact that the state has rested and that Ms. Mignot, on behalf of Mr. Robinson, has rested doesn't mean it's time to start doing online research or talking to other people about the case. Please stay in your information bubble. The lawyers and I are going to stay here a little while longer because we're going to have what's called the charge conference, which sometimes interrupts your day and you have to wait around, where we're going to discuss the law that I will give you so that we can roll straight through what I just described as remaining. Whatever evidence Mr. Pritchett decides to present. And I should say this, he's fully entitled to change his mind and tomorrow morning say, you know what, I'm not putting up any evidence. Okay. Then we turn to closing arguments. The state, because it has the burden of proof, goes first and last with closings. So Mr. Hiles may choose to get up in front of you for a little while, sit back down, let the defendants through counsel or themselves say, here's our closing argument. And then he gets to have last word. Not more time than anyone else. He just can break it into two pieces. When that's done, then I'll charge you based on what we're going to talk about later tonight. And then you will have the case in your hands and in your heads, in your hearts, and you will begin your deliberations. Okay? Any logistical questions? 9 a.m. tomorrow morning. Thank you so much.
All right, we're good.
All right, we have a poll up right now. Will the accused friend show up to testify tomorrow? Yes or no? Currently, no is winning by about 83, 82%. We'll see. You might be here. For those who are asking about the Kelly case, we have that update. If you rewind.
All right. I would like us to handle the charge conference now.
50 minutes.
I would say early tomorrow, but I've got a meeting at 8:30 and we're not going to do it at 8 or 7:45. I shared with you all this weekend the draft charge, and we're about to dive into it. I want to confirm that you want the charge conference taken down, because if you don't, we can release Ms. Rivers and then in the morning get into the record if there were disagreements or whatnot. But we'll do it either way. Mr. Hiles, do you have a perspective on that?
Yeah, Ms. Rivers needs to get, I'm fine with releasing Ms. Rivers for the evening, and we can put any discrepancies on the record tomorrow.
Okay. Ms. Mignot, your view on that?
I'm scared to release Ms. Rivers, Your Honor.
Okay, I fully accept that and respect that. And so I don't need to go any further than that. Is a fair request. I just floated out there because every once in a while, the charges aren't what the case is all about, but there may be some charges here that are problematic. I am going to share my screen and we will look at the jury charge. As I'm doing that, let me describe how I do charge conferences. I'm going to jump through the charge to the areas that I highlighted because those are areas where I have a question or a concern or want your input. In jumping to a place, I may jump over an area where you've got a concern. And so say, Judge, go back to page 2 or whatever it is, and we'll work through it. Based on the edits that I make from our discussion today, I'll create a final charge and I will provide that to everyone as well. And Mr. Pritchett, it's going to be up on the screen for you to look at. Okay, here is our jury charge. If I can get it scrolling. The first...
Very small.
Question I had is on page 3, the charge about evidence. This case is a little different because we have a pro se defendant. And I need to flag for the jurors, and it really depends whether Mr. Pritchett testifies or not.
that nothing Ms. Mignot or Mr. Hiles or Ms. Green said is evidence. And that will be true for Mr. Pritchett as well, unless he testifies. And if he testifies, I have to caveat this little bit. So I'm just highlighting it as a placeholder. If he testifies, it will be anything said by me or the lawyers or Mr. Pritchett when he wasn't on the stand or something to that effect. But certainly if you testify, Mr. Pritchett, what you say under oath is evidence in the case, including your answers to cross-examination questions. So I just flagged that for you all. That'll change. On page 6, I will be giving defendant's choice not to testify because we have a defendant, Mr. Robinson, who is choosing not to testify. We may have 2, but I will remove the highlight on that one, and that will be given. On page 9, principal need not be prosecuted. It doesn't quite fit. I know the purpose. It's why wasn't Voss charged? But that's not what this language says, because no one is saying that Mr. Coleman was one of the home invaders. He was at most a planner, and he may have been the one who reached Mr. Robinson, according to the state's theory. Not saying this is what the jury will find. But either Pritchett or Coleman managed to contact Robinson, who came over and said, I'm in. So I think the concept is a legally appropriate concept, but the standard language doesn't quite fit. I want to start with you, Mr. Hiles.
So I think the only the principal need not be prosecuted. Sorry, that's the language, making it kind of sound like the person who actually physically committed the crime. But if you look at the language of the charge, says any party to a crime who did not directly commit the crime may be prosecuted for the crime upon proof that the crime was committed and the person was a party to it.
But that flips it around. That would be if you had indicted Voss Coleman and not Tyrone Robinson, and all the evidence was, again, I'm making this up, is that Tyrone Robinson did what's alleged here, then the jurors would be saying, wait, you got one of the gunmen. You didn't charge him. You charged Voss and he didn't go anywhere. That's the right, this is what this says. This doesn't describe Voss Coleman.
I think the charge also goes to the fact that it's only about the defendants in front of you now. It doesn't matter if the others aren't prosecuted. And also, essentially, that it goes to the fact that Lindsay and Lauren aren't at trial right now. I mean, I know it's been clear that they are actually charged in this indictment, but the fact that they're not sitting at trial, I think it goes to talk about, you can't consider that fact either. So I do think it is appropriate. And I understand your language, what you're flipping it with Voss, but especially considering the fact that Ms. Kalish and Ms. Riley, who did scout it out and go in and set it up, that they're not standing trial right now. I don't want that to be held against the state.
I think you can get boxed around the ears that they're not on trial now, and that's a fair argument, and can be held against you. It's just not, there's not a legal impropriety the way the state's gone about this case.
That's correct. I fully expect the defense to bring that up, and they're correct in doing so, but this principle that it doesn't excuse the alleged conduct of the other co-defendants for the fact that those two aren't at trial at this point.
But that's not what this language says. What this says is someone who didn't directly commit the crime can still be prosecuted, even though the person believed to have directly committed the crime has not been prosecuted. And that's not, Ms. Riley and Ms. Kalish are being prosecuted. They just aren't on trial. Voss Coleman didn't directly commit the crime. He's not being prosecuted. If you want to send different language, I will consider it, because I think it is a legally correct statement of the law, and really the jurors ought to hear that statement of the law, because they shouldn't be confused. Like, wait a minute, there's something procedurally incorrect. They may decide it's morally incorrect, and that's a great argument for the defense to make, but it's not legally incorrect. It's just not what this says. So I'm tasking you with coming up with some recommended language, because this pattern doesn't fit what you have aptly described. All right?
moving down, we get to the aggravated battery charge. So the actual aggravated battery charge that starts on 10 and goes over to 11, I don't have an issue with that. That is pattern-ish enough, and I think it fits. The non-pattern number 50 from the state, I think maybe went to Christian Riggs, and that count's coming out. Here we have what is alleged to be permanent scarring. That's what it says in the indictment, so we can't change that. And the only testimony about it is, yes, I still have this scar, and you can see it, and I feel it. It's right there. I don't think that fits the remaining aggravated battery count, and I'm proposing not giving it, but I wanted to give you a chance to make an argument for keeping it. Mr. Hiles.
I just lost my.
It's there. Now that comment didn't need to be there anymore. So aggravated battery starts in the upper right-hand corner, goes to the lower left-hand.
Undo.
Yeah, I still think the non-pattern charge is the fact that though you might not be able to see it, it's not always there. It's covered by his head, that his hair is covering the scarring.
Okay. Ms. Mignot, your thoughts about state's non-pattern number 50?
We would take exception to it, Judge. We would ask it not be included. We don't have a serious disfigurement. In fact, there was not even a photograph by the state that was presented of the alleged victims or the victim's head from treatment or.
Right, we have a pre-treatment. I mean, there was a picture of blood coming out of his head and the gash in his head, but not here's how it looks today.
Correct, and that's what serious disfigurement would go to, not the causing of the injury.
Okay. Mr. Pritchett, any thoughts about state's non-pattern number 50?
I adopted this video understood.
Okay. I'm not going to include it, Mr. Hiles. I think that it might have kind of fit for Riggs, but Riggs's aggravated battery is out. As we continue to go through, that's it. Those were the questions I had. So let me turn to you, Mr. Hiles, and ask if there was anything not included that you felt should be included or in there that you think should be out.
I didn't. I don't have any.
All right. You don't have to sound pained saying that. It's okay if I got it right. Okay. Join the club. Ms. Mignot, your turn.
Just the.
Take your time.
Did Your Honor exclude the charge about any weapons since there has been no weapon introduced in this case?
I'm not sure what you mean by the any weapon charge.
I think we might have included in our original draft, Judge.
Okay.
And I know it's late and we've looked at it a lot.
No, but this is the time to do it. And that would be in relation to possession of a firearm or the armed robbery.
Hold on a second.
Sure. Because on the screen now, I just.
You made a mess of it, Judge. Quit clicking on it.
I think it was our charge number 7, Judge, but I'm looking at what you.
An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. I think they can say they use that being struck in the head with the. I think it was the gentleman on the ground that was struck in the head with the gun.
We can move on from it.
Okay. Anything else?
Nothing further from Mr. Robinson.
All right, Mr. Pritchett, do you have any concerns about the jury charge other than the ones we've talked about and I granted your motion?
This is my first time seeing this. I wish I would have seen it before.
So I'm gonna print it out. I'm gonna give it to you now so you can look at it overnight. And if you've got concerns in the morning, we'll talk about them. Okay?
Sounds fair.
That off the top of my head, I can say right now.
What's that?
It was in charge of venue.
Venue?
Yes.
Okay, that's right there on the screen.
I would just like it
Subject matter jurisdiction?
to be specified that the state prove factually what is Fulton County and that they own the territory of where it is today.
I've missed that part of you. It's surfaced in a little while. That's not what the state has to prove for venue. So I hear your request, but I'm going to deny that request.
digs
I
into
will
the
print
soft
out the
bucket.
charge as it stands now, though, so you can take it with you. And if you've got anything we need to discuss in the morning, we will do that. Let me make sure this is double-sided.
We get to see everything on the judge's computer right now. This is going to be fun. Print.
All right, it's working its way this way. I will get a finalized version to everyone. It really hasn't changed much from what you got this weekend. I won't be given state's request number 50. Mr. Pritchett, we need to close the loop on your witnesses for tomorrow. If you're going to call Mr. Abdullah tomorrow, you can't leave here today without leaving behind basic identifiers for him. You found it? Okay. I'm not going to make you put it in the record here, but if you've got it written down, you can share that paperwork with Ms. Mignot and Mr. Heil so they can write it down. Ms. Riley will be here tomorrow. Everyone else, including Abdullah, you've got the responsibility for compelling their attendance. So you mentioned Officer Wright, who I think is now Officer Weems. The only way she's going to get here is you need to figure out how to get her here. Same with Mr. Buckingham, who I think is technically Mr. Heil, things like that. Okay? But you know that. It's what I told you on Friday. I'm helping you with Ms. Riley because she's in custody, but I'm not aware of any of these other people being in custody. And so it's not my role to get those folks here. Okay?
How can I get this?
It is not appropriate for me to give you legal advice on how to do something like that. Mr. Heil, do you have any questions?
If he intends to call Ms. Riley, he also, I can give him contact her. I guess he's going to have to go through her, because she is representing the charges.
Okay.
So I don't know of any conversation that's been had with Ella here up to this point.
So she's been given immunity. What is her ability to say, I'm not going to testify?
I'm not saying I don't disagree with that. But to call her without, I just think it's inappropriate to call her without reaching out to Mr. Keller here. He was here present.
Will you please do that? Shoot him an email, and he's welcome to connect via Zoom. I'll note for the record that Ms. Kalish testified without her attorney present, different person, and Ms. Kalish isn't in jail on other serious charges. But Mr. Pritchett's not in a position to contact Mr. Kelly here. That's not your problem, that's his. But because I know you have a good working relationship with Mr. Kelly here, I'd ask that you shoot him an email that it may be that his client is testifying tomorrow morning. I don't know his schedule, but he or someone else from that firm could patch in via Zoom. We can give them the Zoom link. They're also welcome to be here. I likely will ask Mr. Pritchett to make a proffer as to why he would be calling Ms. Riley, independent of her representation. Anyone who's already testified to be recalled, I need to know
what the recall is for. Because if it's, you know what, I forgot to ask some questions before, that's not a basis to recall someone.
That's was my next issue, and you answered it for me. So, and I just, if this identifying information is not sufficient, I guess, to run a GCIC or criminal background for testimony of the witness, I would at least ask for a little bit of time to get that done. I understand we're giving something away here and it's late, but I'm cool with that. The main concern I would have is if I need to.
Well, let's see what the identifying information is. Can you please give to, if you haven't slid it to Ms. Blake, can you give to Deputy Gordon the identifying information for Mr. Abdullah? Of course, it says the toner just ran out.
Do you have a date of birth?
Tell me what information, not the information, but what information? Is it just a name?
It's a name and an address for Maryland. That's it.
Okay. What makes you think Mr. Abdullah will be here tomorrow if Maryland is where he lives?
Flight.
Okay. Here's what we'll do. If he shows up in the morning, he will give you all his identifying information. If he refuses to do that, he cannot testify. And I'm confident that your crack team of NCIC runners can run an NCIC pretty quickly on him.
They want to know if he has.
And I'd ask you to share that with Ms. Mignot, whatever you're able to generate.
Or convictions.
Yeah. And just SEA.
This is crazy. We'll see what happens tomorrow.
You can give me this. I'll just. It's. I'm gonna just write it down.
All right, Mr. Howes, is there anything else we need to cover while we are on the record today?
Nothing from the state.
All right, you'll be ready to go with your closing argument tomorrow morning.
Yes.
Okay, because it could be that at 9:20, that's what we're doing.
Oh, cool. We're ready. I brought the Monday board bag.
Okay.
I don't intend to use it for the first part, but the videos during the second close, I would like to use that. I'll have everything loaded on it. It's just a matter of plugging it in up here. It takes about 6 minutes for it to boot up.
Okay. And in planning for your closing, you're mindful this is not a murder trial.
No, but it's not a murder trial, but I do think we're entitled to 2 hours because it is a capital case.
Do you have case law that says armed robbery trials get 2-hour closings?
I'll get it to you.
Okay. Be thoughtful about how much time you take with the jury.
But I am thoughtful of that.
Okay.
Prosecutor's awfully comfortable there in the court.
Anything we need to get on the record before we break for today?
Just some clarity as to the closings tomorrow. I have a PowerPoint presentation. I have
You're gonna be awful,
taken pictures of some of the testimony in this case, and I have put them in my PowerPoint presentation. Maybe like a 1 minute or 2 minute or 3 second, that kind of thing. I just don't want to do anything to run afoul, and I need permission to, in my presentation, for example, if I say, well, 911 operator said, she doesn't know anything. Click, 911 operator, which I don't know
Replaying the
anything.
testimony?
Stop. Next slide, that kind of thing.
When you say pictures, so you have on the do not record YouTube video recorded it, and you would be actually playing back witness testimony in your closing?
Yes, not on the do not record.
Oh.
So what happens is once the video is uploaded and posted, it's out in YouTube land and it stays in YouTube.
Okay, got it.
So in YouTube land, you can go and you can.
Yep. No, I recognize that. So you would be playing back for the jury bits and pieces of people's testimony.
Correct. Not long pieces, very short pieces, but to make it not come from my mouth, but to come from the witness's mouth. So I just wanted us to be able to clear that with the court because
there's a good choice to flag that. I've never had that happen before. I'm not saying no. I'm intrigued. I like new and different things. I'm going to let Mr. Hiles think about it as well.
Yes, sir.
But thank you for flagging that. Anything else you want to flag?
That's the only
I've seen
thing,
it
and I
done
wanted
before.
to make sure that I don't have any issues, but I did not violate any rules, Your Honor. It's, in fact, there's a bunch of them out there from many other prior.
Do you have any understanding with Mr. Pritchett as to who's going to go first? Do you want to talk to him about for the two defense closings?
I have not.
Okay. Do you have a preference?
No, but I will find out from him if he wants me to go first.
Okay. If you two would just talk about it, and you don't need to do it right now, but before we
This is never going to end tonight.
and we may not do closings for a while if there is evidence that Mr. Pritchett presents in the morning.
She's going to replay
I don't
it.
want to say, hey, you're up next. And then you're like, oh, well, it's supposed to be the other guy. It's just a lot easier if I say, and by agreement, Mr. Pritchett is going first for the defense. So the two of you sort that out. And if you can't sort it out, then the default is going to be that you go first, Ms. Mignot, because that's just been the flow.
Correct.
But it doesn't have to be the flow. There may be reasons the two of you agree that Mr. Pritchett would give the first of the two defense closings. I'm very open to doing it in whatever way you all agree, if you can agree.
Got it.
Okay.
I like flow for jurors because sometimes changing flows mess things up. But
I leave that to the two of you. So you guys talk about it in the morning or today before folks go. Mr. Pritchett, I'm going to get you, my printer just ran out of toner. So I got to page 8. I'm going to go print out the rest of the jury charge. So you have that tonight. Anything else from your defense?
No, I mean, but in closing arguments, what am I limited to?
So you're not testifying. You are sharing with the jury why they should decide the case in your favor. And you do that by pointing to weaknesses in the state's case, absence of evidence, conflicts in the evidence, but you don't bring in new evidence. Let's say that you happen to know that you had a real bad cold during all this, and so your voice would have sounded funny. And there's no evidence that you had a real bad cold. So if you started telling the jury, another reason that you can tell I wasn't there is that I had a real bad cold then, and you didn't hear any jurors, you didn't hear any of the witnesses say that. That would be improper. Mr. Hiles' head will explode if you try to do something like that. Properly so. And I'll tell you, stop doing that. And if you do it too many times, I'll say you're done with your closing. So it's stick to the evidence or lack of evidence or conflicts in the evidence. And that's what you tell the jury. And so based on that, not guilty, not guilty, not guilty.
Is there any discretion?
Matthew, I've got a question. As soon as they've got a second here.
Read from the Bible.
He's going to read from the Bible? Awesome. Doesn't matter.
But it depends what you read. If you are sharing with the jury an important philosophical principle, I'm making it up. Do unto others as you would have them do unto you. I don't know how that fits in this case. There'd be nothing wrong with you saying, you know what, it says in whatever book that is, do unto others as you have them do unto you. Here's how that applies to this case. But you're not going to be able to read 3 chapters from the book of Matthew. But if the parable of the sower makes sense here, then you might share that with the jury, because it's not facts that are not in evidence that Moses lived to 912 years. That would be a fact, but you get it. If it's a principle that you think is relevant to this,
I can't wait.
You can share
so
that.
Excited
God
for tomorrow.
said, never judge someone only on circumstantial evidence. Okay, you can share that with them.
But if you start going too far into that, Mr. Hiles would likely object, and I would likely sustain it because it's not a sermon. Okay. Anything else?
We may be preached at.
All right. We'll see what happens in the morning. Are you good?
I'm good.
If you don't mind keeping him up, I just need to print out a few more pages, and we'll go off the record. Thank you so much, Ms. Rivers.
All right. And we're off the record. Matthew Harris, here's my question. Here's my legal question. We have, in this case, it's an armed robbery case. It's not a murder case, but they have brought in evidence of prior acts, specifically against Mr. Pritchett, things that Mr. Pritchett did. A prior incident where there was an armed robbery. Now they kept the part out that the victim in that case, in an attempt to escape, jumped from a third-story balcony and died. They kept that part out, but they did include that he had done this, and they were only allowed to bring that in because there was that gang charge that was included. But here in this gang charge, the judge was talking about possibly throwing it out. So I think they're going to stay in. I don't think the judgment is going to be a JOA on the gang charges. But if they did get thrown out, would that mean the whole thing was a mistrial? Because the only way that evidence came in was because there was this gang charge. So if you threw out the gang charges at the end of the trial, would that immediately declare a mistrial for Mr. Pritchett because they brought in evidence that was not allowed based on the charges that went to the jury? That was my thought. That's my question. I'll give you a second to educate me. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. This evidence may be inadmissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. We've got 1 of 2 and 2 of 3. I think it was 1 of 3 and 2 of 3. You type really fast. All right. So I realize that the evidence would normally not be allowed to be brought in against Mr. Pritchett. But because there was a gang charge, they allowed that. The law allows that to be brought in. But if the gang charge were to be yanked at the end of the trial, then you have evidence that you basically have to withdraw or extract from the jury's mind about a prior that wouldn't have been allowed had this only been a home invasion robbery without a gang charge. I think that when the judge was talking about how he regrets not separating that out, the judge gave the jury limited instructions to the state to state the prior bad acts evidence were provided for the gang charge, which was dismissed, cannot be used for the remaining charges. Okay. So you're saying I should probably listen closer to trial. That'll help. All right. Thank you. All right, we are going to end it up today. For those that didn't follow, we did get an update from the Kelly trial. The state has elected not to pursue charges against Mr. Kelly. They are going to be filing to dismiss the charges against him. The judge will accept that filing and grant it. The bond for Mr. Kelly is going to be returned. The court has also ordered that all confiscated material or belongings of Mr. Kelly's, talking about guns, clothing, anything, phones. The gang charge was not dismissed. Sorry, it was just a question. But all that has to be returned. So Mr. Kelly gets it back. If Mr. Kelly gets that back, that is literally the evidence that has been used in this crime or used in this trial. There's no way in my mind, even if the judge dismisses this without prejudice and says at some later point you can refile, and they get, down the road 2 years, they decide, we're going to refile. Now they have to go out and they have to retrieve that evidence again. And you've got chain of custody issues and tests that they have the right to perform on it. It seems like if he gets the evidence back, this is going to be dismissed with prejudice. That's my pick. No court for Daybell tomorrow. Thank you very much, Ashley. Appreciate that. Let's see. Tomorrow we have the accused witnesses in the morning, then closing statements. I don't think the gang was dismissed. I think the only charges the judge is still debating on on dismissing are the firearm charges, which earlier on in the trial, the judge ruled that the gun was not coming in because the gun that they have, which they think matches, was confiscated in another crime. Somebody else had it during an arrest where Mr. Pritchett was also present. Anyway, all right, we're gonna close it out on that one. I have a bathroom to build, and I have some songs to lay down some smoking hot tracks on. So I'm so excited. It's going to be good. It's going to be fire. The only thing I'm worried about is there's so much good stuff to put in it. I know I'm going to leave something out. I don't want anyone to feel offended or hurt that their reference was not included. There's just so much good material in LawTube to rap about. So we're going to get there. Maybe we can listen to it. Hopefully I can get it ready for, I don't know, verdict watch, maybe? Angela, I think I am going to take a look at the opening. I did take a peek at the very opening of the KR trial, Karen Reed, the defense opening. It started with a bang. So that's gonna be hot as well. All right, if you need more legal content, as always, check out the videos over on Matthew Harris Law. That's where I learned everything I know about law. Thank you, Matthew Harris. Appreciate that. Tomorrow, I think they start at 9 o'clock, which means we'll start probably 8:30. I say that every morning, but then it never happens. Thank you for our amazing mods. Thanks to this amazing community for making this wonderful. Appreciate it. Thank you. Thank you very much. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe. So we go live again tomorrow morning with the closing chapter, I think, on this case. Dolphin Lover says, don't forget the people. Ro, Runkle, Kurt, Dr. Joe, Melanie, Megan Fox. I'm not going to get them all. I think I'm going to leave Dr. Joe out of this one. He's going to be safe, marked safe from my rap. Everything I learned about audio quality of great videos, I learned from Recovery Addict. Hopefully your wealth of knowledge is not as small as my knowledge about the law. Hopefully I taught you well. You guys have a good one. Good night. We'll see you.